Much. And we will now move to the next item of business, which is a debate on motion number S4M0654 in the name of Nicola Sturgeon on the Scottish Independence-Referendum franchise bill. I invite members who wish to speak in this debate to press the request to speak buttons now, and I would call on Cabinet Secretary Nicola Sturgeon to speak to and move the motion. Please, Cabinet Secretary, 14 minutes.
Thank you. Thank you very much indeed, Presiding Officer. I am very pleased to open this afternoon the debate on the general principles of the Scottish Independence Referendum franchise bill. This bill represents the first important legislative step towards the referendum, and I want to take this opportunity today to thank all who have contributed to its development. In particular, I want to thank the Referendum Bill Committee for what has been very detailed scrutiny of the bill and a comprehensive Stage 1 report that we will touch on, no doubt, in depth this afternoon. I welcome the support that the committee has given for the general principles of the bill. Let me just start with some context and a word about consultation. Everybody in the Chamber knows the Government was elected in 2011 with a mandate to hold a referendum on our constitutional future, and the date for that referendum has now been confirmed as 18th of September 2014. The proposals that we are debating today are the result of extensive consultation with the Scottish people, and I will say a bit more about that later. That consultation was followed by negotiations between the Scottish Government and the UK Government, and as members are aware, these discussions culminated in the Edinburgh Agreement, which paved the way for the referendum on Scottish independence. The Edinburgh Agreement puts beyond any doubt that this Parliament should legislate for the referendum, and it specifies that the legislation should set the details of the referendum, and that obviously includes the arrangements for the franchise. The bill provides for a franchise which is based on the existing franchise for the Scottish Parliament and local government elections, with one change. That change is the proposal that the franchise is extended to 16 and 17-year-olds, something that I should remind the Chamber, those of us on this side of the Chamber, support for all elections, and are therefore pleased to have the opportunity to make that extension specifically for the referendum. It has long been our belief that the voting age should be lowered. Yes.
Foundations of our country, it seems reasonable to take a measured and mature look at exactly who should be allowed to participate in that decision. Is she open to exploring participation of some prisoners? And if not, could the Cabinet Secretary explain how she thinks excluding people from this most high-profile and significant choice any of us is likely to make will help with reintegration and civic responsibility?
I appreciate this is an important issue for the member. I suspect it will be one of the issues that dominates this debate. I am going to come on to it later on in my speech, so if the member doesn't mind, I won't go into it in detail at the moment, except to say that the legislative process on this or any bill is exactly the place to have the mature and detailed and considered look at any proposal that the member talks about. As I was saying, we have long believed that the voting age should be lowered to 16. Young people, as everybody is aware, take on a number of other important rights and responsibilities at 16. I believe it is only right that they should be fully engaged in the democratic process, and I believe that the proposals in this bill, which we will debate in more detail this afternoon, present a practical and a workable solution to ensure not just some but all eligible 16 and 17-year-olds will be able to cast their vote along with the rest of the electorate next September. The arrangements for registering young voters will closely mirror the existing household canvass. We have designed a young voter registration form which will be sent out to every household alongside that canvass in the autumn of this year. The form has been independently tested, and I am pleased to say that the results show that it works well, it is clear and intelligible. We are obviously committed to ensuring that no barriers exist to prevent eligible voters from participating in the referendum, so the design and the workability of that form is very important. We have worked closely with the electoral registration officers in the development of the bill, and their advice made clear to us that the provisions for registering young voters had to be in place well in advance of the 2013 canvass, and that is the reason for the expedited timetable of this bill and the reason that the franchise has been dealt with separately from the main independence bill, which we will have the opportunity to debate in due course. As I said earlier, we have consulted extensively on the issues contained in this bill. The consultation document, Your Scotland, Your Referendum, was published in January of last year and specifically sought views on extending the franchise to 16 and 17-year-olds. Over half of the people who responded to that question supported the extension of the franchise. In addition, organisations such as NUS Scotland, the Scottish Youth Parliament and Young Scot have been very vocal in their support for extending the franchise, and we've had the opportunity to hear from these groups both during the consultation and during the Referendum Bill Committee's evidence sessions. In addition to the public channels of consultation, we've also had focused and constructive discussions with, as I said a moment ago, electoral registration officers. In addition to that, with the Electoral Commission and other electoral professionals. I want to put on record my thanks to them today because their advice has proved invaluable in the development of the bill, and will continue to work closely with them to ensure the successful implementation of the bill's provisions. The other point I want to make in relation to 16 and 17-year-olds in this contextual part of my speech is that it is absolutely essential that the information that will be collected to allow 16 and 17-year-olds to vote must be treated sensitively. We've been acutely aware of the need to recognise and address any child protection issues during the development of the bill, and we've been helped hugely in this area by the comments of experts in the field. I am confident that the bill takes full account of these issues, although I will be interested to hear the views of members on that particular point as we go through the progress of the bill. Let me turn now, Presiding Officer, to the provisions of the bill in slightly more detail. Obviously, as I've been saying, it sets out who is eligible to vote in the referendum and provides the detailed arrangements for registration of young people. Specifically, the bill provides that eligibility to vote will be based on the franchise for the Scottish Parliament and local government elections. It gives electoral registration officers a duty to collect the information necessary to register eligible young voters who will be 16 by the date of the referendum. It provides for this information to be collated into a register of young voters. It gives EROs a duty to maintain the register of young voters by rolling registration, similar to the provisions around the main register. And it prohibits the register of young voters from being published and sets strict controls on accessing the information it contains. The general approach that we have taken to this bill is to replicate, as far as we possibly can, existing electoral practice, while recognising the need to treat data on young people in a responsible and appropriate manner. Let me turn now to the points raised in the committee's report. As I said at the outset of my remarks, I welcome the committee's full and comprehensive Stage 1 report, which all members will now have had the chance to consider. The committee considered evidence from a wide range of sources, from child protection experts to youth organisations and electoral registration professionals, and I am grateful for what was a very thorough examination of and, of course, support for the general principles of the bill. I want to just comment on one or two of the points that were raised in the committee's report, and as I said earlier in response to the intervention, these are issues that I am sure we will go into in some depth this afternoon. Firstly, prisoner voting. It is the position of the Scottish Government, and I note this is a position supported by a majority of the committee, that convicted prisoners shouldn't be entitled to vote in the referendum. Now, as was discussed during the committee's consideration, the franchise for the referendum is based on the franchise for local government and Scottish Parliament elections, neither of which currently extend to convicted prisoners. The reason for that, in my view, is that if somebody commits a crime which lands them in prison, they break their contract with society, and therefore they lose some of the rights that the rest of us take for granted. And that, as the law stands just now, includes the right to vote in elections. I appreciate, I'll take you in a second, Margaret, if it's okay, I appreciate that there will be those in the chamber today, and as this bill progresses, who want to make a different case, and the Government will certainly listen carefully to the points that are being made. But I think the onus is on those arguing for a change to the status quo position to make that case, and I look forward to the debate that will follow. I want to just touch on... Sorry, I'll take you just now, Margot, and then I'll touch on...
Margaret MacDonald.
With all due respect, Presiding Officer, I think the Minister has set out an absolutist, fundamentalist position. I cannot see how the Government can move from it, and so therefore I wonder why we bother debating it.
Sorry, I was just laughing to myself there at the idea of having a fundamentalist discussion with Margot MacDonald. And, it's in a slightly different context to perhaps previous ones. I'm being very frank and honest about the Government's position. We are not persuaded of the arguments to change the status quo position. But I hope, as I've demonstrated in previous bills I've been in charge of, previous discussions in this chamber, that we'll listen very carefully to the arguments that have been made. I'll take one more intervention at this point before I move on. Patrick Harvey.
I'm grateful, and I'm glad that the Minister is willing to listen to the debate. But at a purely practical level, even if the Government is right that it's unlikely to see a successful legal challenge to this provision, it does seem likely that there will be a legal challenge. Can I ask what assessment the Government has made of the impact of time spent in court fighting that legal challenge on the implementation of this bill or on the timetable for the referendum?
Obviously, we take account of various different things in making our assessment of the timescale. I'm confident that this bill, as it stands, is capable of seeing off any legal challenge. I think particularly on this issue, the ECHR creates rights in relation to elections for state legislatures and not for referendums. I know there was evidence to the committee that backed up that position, and I'm confident that, notwithstanding the points that Patrick Harvey has made, this bill can proceed on the timescale that it needs to do in order to ensure that the referendum, all of the arrangements for the referendum are in place. But as I say, we will continue to listen to the arguments that are made. I want to make some progress. I'm sure we'll come back to this issue during the debate. The other issue that was raised was around service voters. I made clear during my evidence to the committee that no special arrangements are necessary to allow service personnel to vote in the referendum. The arrangements which allow service personnel to vote in elections to this Parliament will be in place for the referendum, and I know the committee has acknowledged that point, and I fully agree that effective joint working between the Electoral Commission, EROs and the MOD will be important to ensure that practical arrangements are in place. The committee also commented on the position of children of service personnel registered as service voters. The proposals in the bill reflect the current arrangements for children of service voters. I note the committee's recommendation on this issue, and I want to reassure Parliament that the Government will investigate the possible options for allowing young people living outside of Scotland with a parent who is a service voter to register in the referendum. It's a small group of people, but nevertheless we will consider their position and report to the committee before stage 2. The committee also commented on awareness raising, and I fully support its conclusion in this area. I think the key to success here is a coordinated approach based on guidance that maintains political impartiality. Our proposals confer responsibility for public awareness on the Electoral Commission, who fulfil this role in an impartial manner for other elections in Scotland. And the last point that the committee raised was around information for electoral registration officers. The point raised there was a valuable one on providing information specifically on the format of applications under rolling registration. Government officials will meet with EROs in the near future to develop guidance on this and other matters contained in the bill. We've worked closely with EROs so far in the development of this legislation and will continue to do so to ensure its effective implementation. To conclude, Presiding Officer, this bill is an essential part of the framework within which the referendum will be held. It provides the mechanism by which all of those who are eligible to vote will be able to cast their vote in the referendum on Scotland's independence. I look forward to the debate that lies ahead this afternoon. I will listen carefully to all of the points that are made, but in the meantime I move that the Parliament agrees to the general principles of the Scottish Independence Referendum Franchise Bill.
Many thanks. And I now call on Bruce Crawford to open on behalf of the committee. 10 minutes, please, Mr Crawford.
Thank you, Presiding Officer. I am pleased, as the convener of the Referendum Scotland Bill Committee, to have this opportunity to contribute to the Stage 1 debate on the Scottish Independence Referendum Franchise Bill. I want to take this opportunity on behalf of the committee members to thank most sincerely the committee clerking team, the staff from SPICE, our committee advisers, for the helpful support and advice they provided during our proceedings. Our thanks also go to the Cabinet Secretary and officials who were very helpful during our deliberations. I should in addition mention all the witnesses who provide us with both oral and written evidence. While obviously too many to mention individually, again on behalf of the committee I would like to give grateful thanks to all of those who gave up their time to provide evidence. Their input made our job so much easier. I would, however, like to thank in particular the evidence we received from Emily Shaw and Andrew Deans, both members of the Scottish Youth Parliament. I can say without hesitation that the committee was impressed by their considered, clear and concise way they put across their points. These two young people are a credit to their families, schools and to the Youth Parliament. Can I also thank my colleagues on the committee for their very constructive and diligent approach to the scrutiny of the franchise bill. I know that like me, many of my colleagues have been aware from the outset of our particular responsibilities to robustly and rigorously scrutinise the government's legislation. I know also that the committee is acutely aware that it is vital that the referendum legislation secures not only the confidence of Parliament, but just as importantly the confidence of the people of Scotland. I turn now to the committee report itself and the detail of the work we undertook. A significant range of issues were examined, and it would be impossible to cover them all in the time available. Therefore, I intend to cover the most significant aspects from my perspective as convener, and inevitably I will have to go over ground already covered by the Deputy First Minister. On the policy intent of the bill to lower the voting age for the referendum to 16 and 17-year-olds, we heard from a number of witnesses. Robin Parker from the NUS Scotland said that his organisation had, and here I quote, for a long time supported the principle of votes at 16. It's extremely positive that the Scottish Government and Westminster Government have agreed that we can extend the franchise for the referendum. The Scottish Youth Parliament similarly said they had campaigned for votes at 16 for more than a decade, and Emily Shaw said that it was fantastic to see the principle being taken forward in the bill. She also said that 16 to 17-year-olds can be just as informed as over 18s are, and it's important they have a voice. Andrew Deans commented that the votes at 16 had received a high degree of support among youth organisations and young people, including a consultation with over 40,000 responses. He said, "We work with 16 and 17-year-olds all the time, and we see that they are very much ready to vote." We heard similarly from Tam Bailey, the Commissioner for Children and Young People, and the organisations Young Scot and the Electoral Reform Society also told the committee they supported the lowering of the age for the referendum. In fairness, we also received evidence from those who were opposed to the move, and in particular from Charles Clegg, a 17-year-old high school pupil who put across his views very clearly. The Deputy First Minister explained the thinking behind the Government's position when she said at the committee, "Young people obviously take on a range of important rights and responsibilities at 16, and we believe they should have the opportunity to have their say on the future of the country of which they are part." Taking on board all of the evidence we received, the committee's decision was to endorse the extension of the franchise for the referendum to include 16 and 17-year-olds, albeit on a majority decision with all members, apart from Annabel Goldie, supporting endorsement. Turning now to the matter of convicted prisoners held in penal institutions. Section 3 of the bill specifically prohibits convicted prisoners held in penal institutions at the time of the referendum from voting. This section, as has been said by the Deputy First Minister, is identical to that made by Section 3 of the 1983 Act for parliamentary and local government elections. The issue of compatibility of Section 3 of the bill with ECHR was considered by the committee. The Deputy First Minister described the legal position as clear and said that the Scottish Government had taken account of all of the legal considerations and arguments in coming to the position in the bill. The committee noted the views of our committee adviser, Professor Stephen Tierney, and the Law Society of Scotland, and their conclusion that a challenge to Section 3 on ECHR grounds is unlikely to succeed. The principle of preventing convicted prisoners voting in the referendum was challenged in written evidence by a number of witnesses, in particular in a joint submission from the Howard League of Penal Reform, among others. Other written evidence also opposed the ban on prisoners voting, for example from Quakers Scotland and the Church of Scotland's Church and Society Council. However, the Deputy First Minister rejected these arguments. She recognised that the position might have to change at UK level in relation to elections, but that was a matter for the UK Government. She said, right now, convicted prisoners who are serving prison sentences do not get to vote, and I do not consider there is a good argument for changing the position for the referendum.
Patrick Harvey.
Grateful to Bruce Crawford for giving way. He's right about the legal evidence that we heard, or the evidence about the legal question, suggesting it may be unlikely that a challenge would be successful and that ECHR rules apply to elections, not to referendums. Is it not also the case that we heard no clear argument as to why, in principle, the franchise for referendums ought to be different from the franchise for elections, and that the ECHR principle should be applied on a moral argument, not a legalistic one?
Well, I think it was quite clear from the majority of the committee, because the majority of the committee supported the Scottish Government, namely that all convicted prisoners should be ineligible to vote in the referendum. I think the basics behind that was if you forfeit your right to vote once you've been incarcerated in a penal institution as a result of committing a crime. That's a pretty simple principle to get a hold of, and I think, and it's quite clear that apart from yourself, Patrick Harvie, and Tavish Scott, who dissented from that conclusion, that the rest of the committee supported the position of the government. But moving on to the matter of votes for service personnel. No longer a minister, but I can do it with the committee, but happy to give way.
I was being Suki, presiding officer. Why was it felt that this would be defeated in court? You haven't explained that.
Well, we had evidence both from the committee adviser, Professor Tierney, and from the Law Society of Scotland. That was the evidence that the committee leaned upon in terms of coming to the conclusion that it would be highly unlikely to be successful in any court action. In regard to the service personnel, as already been said by the Deputy First Minister, there are no need for special arrangements. The Deputy First Minister explained in detail, as is laid out in column 311 from the official report of the 20th of March, the options available for service personnel to register. On that basis, the committee was content with the proposed franchise as noted for in the bill in respect of service personnel, but went on to say, what matters now is that there is effective joint working between the Electoral Commission, EROs and the Ministry of Defence in order to provide information to these personnel about the registration options available to them. The committee also urged the Government, in discussion with the UK Government, to explore all possible options for enabling young people to vote if they are of voting age and are only resident outside Scotland because their family has moved to be with a parent serving in the armed forces, and to report back to the committee prior to the beginning of stage 2. Lastly, I want to take a quick reference to the issue of awareness raising and the specific recommendations in our report. We took a fair bit of evidence in this regard from a number of appropriate organisations, but in particular I would like to thank officials from the Isle of Man, Guernsey and Jersey who took the trouble to provide us with an overview of their experiences. The committee agreed with the witnesses that the key points about awareness raising are the need for a coordinated approach based on clear guidance that maintains political impartiality. The committee also believed that the Electoral Commission has a central role to play in this process, working collaboratively with many other organisations. The committee was not persuaded that bodies other than the Electoral Commission need a duty in law to encourage participation. However, we did say we would expect the Commission to develop in good time a detailed delivery plan to promote effective joint working, to clarify what it expects from others and to ensure an appropriate degree of consistency across Scotland. In terms of raising awareness among young voters in schools, the committee also said it was confident that those involved at local level, including EROs, the teachers already understand what is required. We considered that they are experienced in engaging young people in issues of citizenship in an appropriate and non-partisan way that complements rather than competes with the rest of their education. So, taking into conclusion all of the evidence we received, the committee, following all that evidence, I am pleased to say that the committee recommends to the Parliament that the general principles of the Scottish Independence Franchise Bill be agreed to. Now, I like the sound of that, and I hope that at decision time Parliament will agree with the committee to give 16- and 17-year-olds the right to vote to decide the constitutional future of their own country. Thank you.
Thank you very much. I will now call on Patricia Ferguson. 10 minutes, please.
Thank you, Presiding Officer. In spite of the Referendum Bill Committee having had to work to quite a tight timescale for its consideration of this important bill, I believe that the committee has taken extensive evidence on the matters covered by the bill and has given very serious consideration to the issues raised. But of course that has only been possible because of the assiduous way in which the clerks and their colleagues from Spice have gone about their work, and with the cooperation of witnesses and our advisers too. The purpose of the Referendum Bill Committee is to consider the Scottish Independence Referendum Franchise Bill, the one we have before us today, and the Referendum Bill itself, both of which were made possible by the Section 30 order approved by this Parliament on the 5th of December 2012. And as its title suggests, the Referendum Franchise Bill mainly deals with the issue of who can, and just as importantly, who can't vote in the referendum, and how the decisions made in this regard can be implemented with a degree of certainty. In the case of the decision to give 16 and 17-year-olds the opportunity to vote in the referendum, there were also issues about how we treat data relating to young people to ensure it was both securely held and sensitively used. But in summary, the franchise will be the same as that for local government and Scottish Parliament elections, with the addition of 16 and 17-year-olds. Now, Scottish Labour agrees that 16 and 17-year-olds should have the vote. And I was struck by the point made by Robin Harper of NUS Scotland, who suggested that young people would have to live with the consequences of the referendum, whichever way it goes, for the longest time, and therefore, Mr Parker suggested, have the greatest stake in the decision. And I think that's a point well made. Bruce Crawford, our convener, has already mentioned the evidence given by Andrew Deans and Emily Shaw, MSYPs, and I think it's fair to say that if anyone had any doubt about the wisdom of allowing 16 and 17-year-olds to vote, it was put to bed when we heard the mature and considered evidence that they gave to us. The committee also noted that the draft bill specifically prohibits convicted prisoners held in penal establishments at the time of the referendum from voting, a position with which Scottish Labour concurs. Now, this Parliament is of course bound by the need to comply with ECHR, but we were reassured by the advice from the committee adviser and from the Law Society of Scotland that the relevant provisions of ECHR, that is, those that deal with the issue of prisoner voting, refer to elections involving a choice of legislature, and that previous cases reinforced the fact that referenda were not covered by this protocol. Happy to.
Patrick Harvey.
I'm grateful, and I'd be interested to know whether Patricia Ferguson can advance a reason in principle, not whether the ECHR rule about elections is a good or a bad one, and whether prisoners should have the right to vote in elections or not, but why a referendum ought to be held to a lower human rights standard than elections.
Patricia Ferguson.
Well, I think the point that Patrick Harvey made is actually one that is worthy of further discussion. And I would hope that we would have a discussion about that in the context of how we deal with prisoners and what the role of sentencing is. I have to say that I couldn't agree with the amendment that I understand is going to come from some members in the Parliament today, or perhaps at a later stage, because I think that the threshold is probably going to be too high. And the kind of prisoner that we're talking about is not the kind of prisoner that has committed a low-level offence, but actually someone who has committed a fairly serious offence. And I would in principle object to them having the vote in any situation. But I think that we know, well, not on that issue, because I want to move on, if I may. I'm sorry, I can't take them all. But for the avoidance of doubt in this particular matter, and as we know that this provision is likely to be the subject of legal challenge, and as Professor Tierney indicated to us that while he thought the balance of probability lay with that appeal not being successful, that we would wish to see the legal advice that the Scottish Government has taken in this regard, and we would hope that the Deputy First Minister would make this available to Parliament as soon as is possible. It's important, I think, though, to note in that context that remand prisoners, and indeed some civil prisoners, together with people imprisoned for fine defaulting, do retain the right to vote, and we, like the committee, would seek the Scottish Government's assurance that these categories of people have every opportunity to exercise an informed choice in the referendum. The issue of whether or not service personnel will be able to vote is an important one and has been the subject of some media speculation. And I note that service personnel have the same opportunity to vote in this referendum as they have in other elections, and that they can vote as an ordinary voter if they are able to register at an address in Scotland, as a service voter or as an overseas voter. In evidence, the Electoral Commission pointed out that this provision was not available to all service personnel all of the time, and that service personnel's ability to register depended on their particular circumstances, with electoral returning officers having to make a determination based on the information with which they were provided. But we also noted that the Electoral Commission was cooperating with the MOD to provide information about registration for service personnel, and I would hope that it will be possible to ensure the widest possible franchise amongst service personnel. Kevin MacDonald of the Information Commissioner's Office drew attention to a small but important group of people who were likely to be disenfranchised, and they are the children of service personnel. The Government has argued that this is no different from what happens in other elections, but I would argue that it is in fact a direct consequence of the fact that we are now extending the franchise to young people aged 16 and 17, young people who could reasonably be expected, because of their age, to still be living with their service personnel parents. And I would accept that this is likely, as I say, to be a relatively small number of people, but I do most earnestly hope that the Scottish Government will work with the UK Government to find a solution to this problem. And I do welcome the Cabinet Secretary's comment today in that regard, but I do think that it's important that if we're going to say that all 16 and 17-year-olds will have the vote, then that we mean all 16 and 17-year-olds will have the vote. We now know that the UK Government has indicated that it will postpone moves towards individual voter registration in Scotland until after the referendum, and that is welcome. But we would also hope that wide variations in the start date for the annual canvass could be avoided, and that returning officers would begin their canvass as soon as possible after the 1st of October to allow as much time as possible for registration. The policy memorandum for the franchise bill anticipates that registration will mirror the existing processes rather than introduce a new procedure, and so it aims to ensure that young people will register through an extra form which will be provided to households alongside the usual return form with which we are familiar. And I note that it will also be possible for the provision of rolling registration up until 11 days before the referendum. Now, in evidence to the committee, Andrew Deans, a member of the Scottish Youth Parliament to whom we referred earlier, was anxious that parents may not understand that they could add their teenage children to the list, and suggested that there should be more emphasis on the rolling register. But another important point made by the MSYPs in relation to the registration form was that it would be better to indicate by reference to actual dates who was eligible to vote, rather than by referring to the qualifying age. I think that the MSYPs made a very valid point here, and I hope that the Cabinet Secretary will give that serious consideration. As I mentioned earlier, the committee were rightly concerned to make sure that the data collected in relation to young people would be handled and managed sensitively, and I was pleased to hear that the witnesses who commented on this area of the bill felt that it had benefited greatly from suggestions made during the consultation process, and that in its current format would protect young people in a robust way, with access to the register of young voters being strictly limited. This is a crucial point, as teenagers as young as 14 may be included in the register. I believe that the measures proposed in the bill in this regard are welcome and will protect and safeguard data appropriately. Now, regardless of where you stand on the issue of separation, we can all agree that it will be important that people are aware of the ways in which they can register and vote in the referendum. The committee noted that there is a crossover between the franchise bill and the referendum bill in this regard, and we noted a number of issues which we would want to consider further during our scrutiny of the referendum bill in relation to awareness raising. But like the committee, Scottish Labour believes that it is vital that all those eligible to vote understand how to go about registering, and that they should be able to access advice that is both impartial and accurate. This is particularly important as we try to encourage as many young voters as possible to participate. I think I'm actually in my last minute, Mr Robertson, sorry about that. I think the committee was right to suggest in conclusion 136 that awareness raising needs to be coordinated, clear and impartial. And the committee took very seriously too the evidence presented by the National Deaf Children's Society that the need to ensure that those who face barriers in their everyday lives could also be informed, so that they could also be informed participants, is vital. And Scottish Labour does hope that information will be available in a variety of languages and formats. One other area where the Cabinet Secretary could usefully provide clarification is in relation to Section 11 and the delegated powers which it bestows on ministers. These powers are wide-ranging in nature, given that they include the power to modify any enactment, including the bill itself. And while I note that the provisions of this bill are narrow, it is an unusual power for Government to seek, so I would be grateful if the Cabinet Secretary could perhaps comment further on the possible uses of these powers when she closes the debate. Presiding Officer, in summary, we would seek assurances from the Cabinet Secretary on the legal advice she has received in connection with prisoner voting, and that the Scottish Government will take seriously the matter of the wording to be contained in the registration form to make it clear which young people can vote. And we would hope that the Scottish Government would work with the UK Government to ensure that the children of service personnel are in that list. Presiding Officer, Scottish Labour will support the general principles of the bill at stage 1.
Thank you. I now call on Annabel Goldie, 6 minutes.
Thank you, Deputy Presiding Officer. The referendum next year is the most important decision to be taken by Scotland in 300 years, and I'm glad that the Westminster and Scottish Governments were able to agree that there should be a referendum before the end of next year with one question, because this issue must be resolved. It's then, of course, important to confirm the franchise arrangements for such an election. Now, as I understand it, normally any such franchise directions would be contained in the bill constituting the referendum, as was the case with the AV referendum last year. However, the desire of the SNP to extend the franchise to 16 and 17-year-olds with the new and additional administrative requirements for compiling a new electoral roll to deal with that and the timescale involved meant a separate paving bill was necessary. I serve in the committee scrutinising the bill, and I too would like to pay tribute to the clerks, to Spice and to the committee advisers, Ian Grant and Professor Stephen Tierney, all of whose input I found very supportive and very helpful. I also want to thank our convener, Bruce Crawford, for his fairness and inclusiveness, and during the more testing moments of the scrutiny process, his quite exemplary patience. I am satisfied that the scrutiny process has been thorough and the Stage 1 report a fair reflection of the committee's deliberations. If I may now turn to more specific aspects of the bill, Section 3 prohibits convicted prisoners held in a penal institution from voting. Deputy Presiding Officer, I agree with the Scottish Government's view on that issue, and given the recent rulings by the European Court of Human Rights which question such a blanket prohibition, it was, in my opinion, correct to deal with this in the bill. However, I also agree with the principle underpinning the prohibition. In my opinion, convicted prisoners serving custodial sentences have, by committing their crimes, sacrificed their entitlement to vote. And the best way to the best way to preserve that entitlement is, in fact, to stay out of prison.
Alison McInnes.
The member might be interested to know that in 2011-12, 40% of those sentenced to severe assault or attempted murder were dealt with in the community and therefore never lost their vote. Would the member therefore agree that a blanket ban on prisoner voting is not a coherent position?
Annabel Goldie.
Well, I think the distinction is the custodial element, and I've made clear my view. I think if someone has sacrificed their right to be at liberty in society, then other consequences follow, and one of that, to me, is loss of franchise. I recognise a member may disagree with that assessment, but that's a view which I hold. I'd rather make progress, Ms MacDonald, if you would excuse me. Now, interestingly, and some members have referred to this, both Professor Stephen Tierney and the Law Society of Scotland raised the issue of possible legal challenge by a disenfranchised prisoner. Professor Tierney considered referenda to be exempt from the relevant provision of ECHR, but he did not dismiss the possibility of a challenge, although he did consider such challenge unlikely to be successful. And the Law Society took a very similar view. Now, in fairness, the Deputy First Minister was examined closely on this point by the committee, but was very clear about the legal advice which the Scottish Government had received. Presiding Officer, in everything there is a risk of legal challenge, and I am satisfied on the basis of the evidence and opinion submitted to the committee that the prospect of a successful challenge is minimal. The main thrust of the bill is, of course, to extend the franchise to 16 and 17-year-olds. The previous very limited application of that extension to pilot health board elections provided no useful basis for discussion other than recognising abysmal turnout levels. So, on the principle of using the referendum as an experiment for extending votes to 16 and 17-year-olds, my party is not supportive. Now, Deputy Presiding Officer, that is not to say we do not consider there is a debate to be had. We think there is, and that would be welcome. But my party feels that this step is precipitate and premature. We would have welcomed broader discussion and consultation involving the Electoral Commission. And so for that reason, my dissent to the proposal was noted in the committee report, and my party will vote against the bill this evening. I think I need to make some progress. I've got enough to get through. I'm sorry, Ms MacDonald. On a purely personal note, Deputy Presiding Officer, people may think the views I hold now are disquieting. You should have seen my views at the age of 16. Scary. Experience of life, not least the workplace, where to temper them. Although I may disagree with the extension of franchise, I have to say the examination by the committee of the process was useful. And for me, two important elements emerged. Firstly, the introduction of individual voter registration by Westminster is welcome, but the timing of that legislation could have placed an impossible administrative burden on electoral officers preparing for the referendum. So I was very relieved to learn of the reassurance given by the Cabinet Office at Westminster to the Deputy First Minister that individual voter registration will not start until after the referendum. And I do look forward to confirmation from the Scottish Government that the necessary Westminster statutory instrument has been enacted to ensure that that is the case. And secondly, there was understandable interest expressed in ensuring that young people voting for the first time in the referendum should have access to information. I agree with that, but the distinction between provision of information and propaganda is a fine one. Now, it's right that the Scottish Government has no control over local authorities in this respect, but there is a huge obligation on local authorities to strike a proper balance between the reasonable provision of information to young people to increase awareness, but stopping short of anything which reeks of a coercive attempt to influence. And equally importantly, young persons preparing for exams must not be diverted from essential study. And in conclusion, Deputy Presiding Officer, the delegated powers arising in Section 11 of the Bill, they are wide, wider I think than might normally be expected. They are subject to affirmative procedure, but I would very much hope such breadth and scope of delegated powers in legislation in this Parliament to be the exception, not the rule.
Thank you very much. We now turn to the open debate, speeches of 6 minutes. Could I ask members who wish to speak in the debate to make sure the request to speak buttons are pressed, and that's particularly important after members are taken for interventions. You must repress your button. As I say, speeches of 6 minutes. We're quite tight for time, so Annabel Ewing to be followed by Helen Eadie.
Thank you, Presiding Officer. And as a member of the Referendum Scotland Bill Committee, I am very pleased indeed to have been called to speak in the Stage 1 debate on the Scottish Independence-Referendum franchise bill. And I too would like to take this opportunity to thank all who gave evidence, to thank Spice, our committee advisers, and to thank the clerks for their very efficient handling thus far of the franchise bill. And as we have heard already this afternoon, the franchise bill makes provision for the actual franchise that is to be applicable for the independence referendum to be held on 18 September 2014. And broadly speaking, the franchise will be the same as that for the 1997 devolution referendum. That is, it will be based upon the local government register in Scotland. And the approach of both the 1997 devolution referendum and of the upcoming 2014 independence referendum reflects what is widely regarded as best international practice on referenda, whereby residency is considered to be the most appropriate criterion for setting the right to vote. And I think it's interesting to note, Presiding Officer, that the committee unanimously agreed with this approach, and I refer the Chamber in this respect to paragraph 29 of the committee's report. And I would also like to add, actually, at this point, Presiding Officer, that the deliberations of the committee as a whole on the franchise bill were really, broadly speaking, of a consensual nature, which I think is a credit to all members of the committee, and particularly to those representing the unionist parties, who I think it is probably fair to say did not have as an overriding objective the holding of an independence referendum in the first place. But as far as the franchise is concerned, there is, of course, one key difference from the approach taken in the 1997 referendum, and this, of course, concerns the extension of the vote to 16 and 17-year-olds. And I personally am delighted that some 120,000 of our citizens aged 16 and 17 will be able to register to vote in the independence referendum. And I do speak as a long-term supporter of a reduction in the voting age to 16. And that has been a long-term objective of the Scottish National Party. And indeed, in this respect, I recall that my mother, Winnie Ewing, in her maiden speech in the House of Commons following her sensational victory in the Hamilton by-election in 1967, indeed called for a reduction in the voting age from the then minimum age of 21 years to 18 years, with indeed a marker being laid for future reductions. Certainly.
John Mason.
I very much agree with what the member says about 16 and 17-year-olds. I was in some schools where young people were saying they didn't have a lot of confidence that they understood all the issues. How would she respond to a young person like that?
Annabel Ewan.
I thank the member for his intervention. I believe that as we progress further towards the referendum date of 18 September next year, that young people will feel quite confident that they have the information that they need through a variety of means. I had suggested in committee, perhaps, Presiding Officer, we could have an indie app, which went down quite well with the young witnesses there. So there will be many means, and I'm afraid I would like to make a wee bit of progress. I've just taken one, thank you. There will be many means by which information will be made available. And indeed, the evidence that the committee received was very much in favour of lowering the voting age, with supportive statements having been received from NUS Scotland, representatives of the Scottish Youth Parliament, Young Scots, Scotland's Commissioner for Children and Young People, Children in Scotland, and the Electoral Reform Society. For the sake of completeness, the evidence received in favour of lowering the voting age was not unanimously in favour. There was one individual who made a submission against the proposition. And as far as committee members are concerned, there was agreement, except, as we have heard this afternoon, from the Conservative Party. On the issue of lowering the voting age in general, again, the Scottish National Party is in favour of that for all forms of election. It's not clear from what Annabel Goldie said today what the Conservative Party position is, and it's certainly not clear, I have to say, what the Labour position is, who talk about being in support, but then also talk about simply actively looking at the matter in terms of their 2015 Westminster manifesto. But perhaps they'll take the opportunity this afternoon to clarify their position. What is clear is that a yes vote in 2014 will secure for this Parliament the power over the voting age for all elections held in Scotland, and that, I believe, is how it should be. Presiding Officer, there is one other key important aspect of the franchise that I wish to touch upon in the time remaining, and that, of course, concerns the issue of service personnel. And again, the approach adopted in this independence referendum is the same as that in the 1997 devolution referendum. And, of course, the right of service personnel to vote follows the arrangements that are already in place. And I would like to quote, in this respect, the Advocate-General, Lord Wallace of Tankerness, who spoke during the Section 30 order debate on 16 January 2013 in the House of Lords. And he said, members of the armed forces will be able to vote in the referendum if they are on the register in Scotland, either as a resultant of address in Scotland or a qualifying address showing a connection to Scotland, such as service accommodation in Scotland, an address in Scotland where they would be living if they were not in the services, or an address in Scotland where they have lived in the past. The same rules apply to spouses and civil partners of members of the armed forces. That, I think, is very welcome. It is certainly as it should be, and of course the committee was happy to endorse that position. One issue that has arisen concerns the position of 16 and 17-year-old children still living with service personnel resident Firth of Scotland, on the basis that the current system is a Westminster system that is based on the actual service personnel and their spouse or partner, and does not even cover 18-year-old children still living with such service personnel. It is very welcome to hear that the Scottish Government will do everything it can to persuade the Westminster Government to do the necessary here to allow the children, 16 and 17-year-old children of such service personnel, to vote in the independence referendum. Thank you, Presiding Officer.
Thank you very much. I call Helen Eadie to be followed by Rob Gibson.
Thank you very much, Presiding Officer, and I'm very pleased to say thank you to all of those connected with the work of the committee and to the convener for the very detailed response that they have given to the Parliament in their report. And I think this Stage 1 debate on the referendum bill for Scotland is an opportunity to move the debate beyond the technical issues of the franchise to a wider discussion of how we can encourage people to get involved in the debate and ensure that they are registered and ensure that the widest cross-section of Scottish society turns out to vote. And I welcome the extension of the franchise to 16 and 17-year-olds, and I believe, however, that this should apply to all elections and not just to the referendum. My party, the Labour Party, believes that special consideration should be given to the protection of personal data of this age group and welcomes the safeguards contained within the bill. It's worthy of note that when the Health Committee did debate and help to promote the legislation that enabled and direct elections for health boards, the franchise was extended in that particular instance to 16 and 17-year-olds. So this is not a first for the Parliament. We have been there before. I'm very pleased the Government is considering how the franchise may be extended so that 16 and 17-year-olds who are based abroad because their parents are posted abroad with the UK's armed forces can vote in the referendum. That would be very welcome if the Government agrees to amendments along those lines. And that's just an example of the type of detailed work that the committee has been able to expose for us. It is very important that the referendum result is certain and accepted internationally so that Scotland can move forward, hopefully as part of the UK from my perspective, with the independence question settled. And with this in mind, whilst we understand that the Scottish people living in the rest of the UK and abroad feel they should be able to vote in the referendum, we do not intend to challenge the Scottish Government's approach in relation to expats and accept that expats may not vote in the referendum unless they are ordinarily able to vote in the Scottish Parliament elections. Yes.
Margaret MacDonald.
I thank the member for giving way. I noticed at yesterday's press conference when Gordon Brown introduced his ideas for the referendum and said that in Scotland, Scots should feel as responsible for the well-being of people south of the border as they do for people here. Now, shouldn't that therefore extend to the franchise? Shouldn't they have a say? That's what I was wondering when she said that they would have no franchise.
Helen Eadie.
I think the point is that where people are able to vote in a parliamentary election here, that to me is a sufficient criteria, and that's what the report says, and that's what I believe the Government's position is, and I entirely support that position. I think that that's a separate issue from the wider moral aspects that has been referred to by Margaret MacDonald. I'd like to turn now to my thoughts on the issue about prisoners, and I have to say I did read with interest the email that we did receive from the Scottish Human Rights Commission. But as the party that brought the European Convention on Human Rights into the UK law, we take the issue of whether or not prisoners should be able to vote in the referendum very seriously. The Scottish Government says that their intended approach to exclude prisoners from voting in the referendum is not contrary to the UK's human rights legislation. Given the importance of this issue and the Scottish Parliament's commitment to complying with the ECHR in all legislation it passes, I call upon the Scottish Government to inform us what legal advice they have had on this issue and to publish this legal advice. I think it's very important because I think that we need to really have this as part of the movement from stage one of the debate to stage two. We really need to probe this issue, in my opinion. No, not at the moment, thank you. A lot more seriously, because I do think that this is an opportunity to develop a distinctive alternative to the existing United Kingdom blanket ban on convicted prisoners voting in elections. This could be a course which brings us closer to the practice in other European democracies such as Denmark, Finland, Ireland, France, Germany, Sweden and Switzerland. And as such, the Commission reminded us that the Scottish Parliament to have a debate on whether all prisoners should be banned from voting in the referendum as expressed in the draft bill.
Final minute.
The Commission proposed that this section of the bill be revised to adequately reflect the values placed in Scotland on human rights, social justice and the effective rehabilitation of offenders. And I think that when you look at the other countries where all convicted prisoners serving prison sentences of the right to vote are currently disenfranchised are the UK, Armenia and Bulgaria. Much as I love Bulgaria, I have to say I think they're wrong in this regard. Estonia, Georgia, Hungary and Russia. And I think the key point that the Human Rights Commission are making here is based on on what is reasonable and objective justifications, such as the type of crime committed or the length of the service. They are not proposing that every prisoner be given the right to vote. They are proposing that, for example, we know that there are many women, particularly women, who are in prisons in Sochi and other prisons where they are there for a bill not being paid. Is it reasonable to ask a woman who is in prison for not having paid her TV licence or her parking fines to be disenfranchised? I don't think so, but for the serious violent criminals, then yes, I would ban them from the right to vote. And I think we do have to distinguish in what we're talking about here, and this is worthy of a lengthier debate. Thank you, Presiding Officer.
Thank you very much. I now call Rob Gibson to be followed by Graham Pearson.
Thank you, Presiding Officer. As a member of the Bill Committee, I am delighted to speak in support of that today, recognising that the franchise should be the same as in the Scottish Parliament, more or less, in local elections, that the extension of it to 16 and 17-year-olds is most welcome, that there should be no extension to convicted prisoners held in penal institutions, that service voters have a right to vote in Scottish Parliament elections and local elections, and that those rules should continue. I am really pleased that we looked at in great detail questions of how 16 and 17-year-olds would be involved, Presiding Officer. And at paragraph 108 in our report, we say, as part of its wider scrutiny of the issues raised by the bill, the committee has taken considerable evidence on how voters, particularly young voters, enfranchised for the first time, can be given the information they need about registering for and voting in the referendum. This awareness-raising... Yes, certainly.
Neil Findlay.
Thanks very much. I was recently, as part of a deputation, doing election observing in Venezuela, and the people over there asked me a very basic question that I couldn't answer, and I just wonder whether the committee has considered this. And that is, how do we ensure that the person who turns up to vote, whether it's in a referendum or on polling day, is who they say they are?
Rob Gibson.
The prospect of making sure that we run elections and this referendum on the same basis as British elections have been run and Scottish elections have been run over the last decade and centuries before that suggests that when we have local polling places, many people are known to the officers in charge, and that in fact we do not have a situation, as occurred perhaps in Northern Ireland, where
please.
Vote early, vote often was something which was tolerated far too often. But as we talk about impersonation, I think it would be far better to talk about awareness raising, and that's a very positive matter. It's a fact that, as was alluded to by the convener of the committee, that the members of the Youth Parliament raised key questions about the variability of and the quality of materials available for school pupils, because 16 and 17-year-olds need to be assured that they are getting an excellent sense of information. And we have established through our interrogations that indeed the Electoral Commission will have a major part to play in providing that. But I'd like to dwell on a couple of points about the way in which the different witnesses put this forward. And Bruce Robertson, in particular, from the Association of Directors of Education, said that information about the referendum would be provided at times when pupils are already expected to focus on matters other than their qualifications, although it had spin-offs into other areas. He described this as a happy balance that we need to strike, because they have their curriculum to answer. But he also pointed out that not every school offers modern studies, as at column 291 in our report. That is where the work of the collaboration across 32 education authorities and with School Leaders Scotland, which is the Association of Secondary Head Teachers, will enable people clearly to understand what is happening. Because, certainly,
you mentioned... You mentioned modern studies in relation to educating young people at schools. As a former modern studies teacher with onset of curriculum for excellence, would
Would you acknowledge that it's the responsibility of the whole school community to raise awareness of the referendum and not solely the responsibility of under pressure modern studies teachers?
Bob Gibson.
As a former modern studies teacher myself, I could but agree, because in fact many schools do not have modern studies, and that was the point made by the members of the Youth Parliament, and that it's necessary to find ways to ensure that everybody gets a fair chance, whether they live in Helensburgh or Helmsdale, as the phrase was put. I'm sorry I don't have time. I'm already far behind. Mary Pitt-Caithley, who is the convener of the Electoral Management Board, but also the Chief Executive of Falkirk Council, said that she could reassure members that this issue of the guidance that has been consulted on would be expect schools to use the material that is made available so that there is awareness of what is being said, and they will support the Directors of Education colleagues in making this, taking this issue forward. So I'm delighted that we now look forward to the Electoral Commission providing arguments about awareness and about the issues in a fashion which will not be taking a partisan view, and that indeed a detailed delivery plan, as was mentioned by the convener, is to be expected, because there's other suggestions from other elections that the Electoral Commission is perhaps finding some of these things difficult, and it will be very important that at an early stage our children in our schools get a balanced set of materials which are provided, and we will have to keep that matter under scrutiny. I support the general wishes of the bill, and I'm happy to say that the Government is moving very much in the correct direction.
Thank you very much. I call Graham Pearson to be followed by Richard Lyle.
Thank you, Presiding Officer. Following the recent media coverage exposing just how nasty, offensive and vitriolic elements of the debate on independence have become, particularly online, I am pleased that today's debate has proved to be one that reflects a mutual respect, consideration and minimal conflict. I, along with many parliamentary colleagues, favour the extension of the franchise to include 16 and 17-year-olds across all elections. My regret in this instance is that the extension applies solely to the referendum, and that the registration process for under-18s has therefore been rushed. And I hope that the issues that have been raised by members in this chamber in that context, in terms of their concerns, are properly addressed in the time that's left. I do also harbour some concerns that under-18s will not be in a position to vote in an informed manner. As part of my work across the south of Scotland, I often visit schools and speak with teachers. The general consensus with teachers, and I'm frightened to say this given that so many modern studies teachers are in the chamber, but particularly those in modern studies department, seem to be that as yet many pupils are not adequately informed or prepared for the responsibilities that come with voting. Of course.
Patricia Ferguson.
Grateful to the member for taking the intervention, and I would just say that I would be slightly worried if the Chamber just spoke about schools this afternoon in relation to young people, because not all young people are in education. Some are in apprenticeships and some are out in the world of work, and it's important they too have access to good and impartial information.
Graham Pearson.
I'm very grateful for the member for making that point, and it saves me making a similar point later on. There's no doubt that pressure on young people to adhere to others in terms of their views will be substantial, and we would hope that in allowing those under the age of 18 but beyond 16 to vote will allow them to play their part fully as we go towards the independence referendum. The Cabinet Secretary indicated during her speech that she believed that she could survive a legal challenge in relation to the extending the franchise to those serving custodial sentences. I would have hoped and anticipated that she would want to do the right thing and the just thing, and not solely what she can get away with in terms of ECHR. During my previous police service, I dealt with countless prisoners who were in custody for a huge variety of crimes. My experiences have led me to the view that those in prison should not be subject of a blanket ban on participation in the electoral system. Scotland is one of the very few, part of a very small group of European countries who impose such restrictions. And it was mentioned earlier, Armenia, Bulgaria, Estonia, Georgia, Hungary, Liechtenstein and Russia. It seems strange to me that the line that we would use to determine franchise is a custodial sentence, no matter whether you are spending weeks in prison for shoplifting or something similar, or a life sentence for murder. I therefore believe that prisoners serving short sentences for less serious offences, the exact nature and length of those sentences we can debate and determine, should be allowed to participate in all elections in Scotland. I also believe that once granted a vote, individual prisoners should be made responsible for registering for their vote and arranging the vote to be submitted, and not left to the prison authorities to do that on their behalf. My final point relates to my concerns regarding the government position following the result of next year's referendum. If Scotland votes to separate from the rest of the UK, and I hope and believe that the majority will vote against separation, whilst I will be extremely disappointed and do not believe that it will be a positive step, I will accept the will of the Scottish people and endeavour to make Scotland the best place possible, whatever our relationship with the rest of the UK. I wonder if members of the Government and the SNP members will make the same pledge and state their intentions in the result that Scotland votes to remain part of the United Kingdom. I find it particularly concerning that some nationalist members in the past have stated their desire to hold another referendum if the result of the first one is not to our liking.
Final minute.
It's been quoted, if we don't get enough votes, then it's believed we should go for another referendum, especially if it's close. It would be unfair to the people of Scotland if it's close to tell them that it's finished. I've got to say to the Chamber, this isn't Brigadoon we're dealing with. There must come a point where we recognise the consensus reached by the voters in Scotland and accept their will. I hope that all members will offer assurances that we will accept the result of next year's referendum and subsequently prioritise the best interests of the people of Scotland. Thanks very much, Presiding Officer.
Thank you. I now call Richard Lyle to be followed by Linda Fabiani.
Thank you. Thank you, Presiding Officer. I'm pleased to take part in today's debate. Today is historical. For those who do not know, I joined the SNP when I was 16 in 1966. Hard to imagine, nearly 47 years ago. Yeah, you're older than me, Margot. The 18th September 2014 is Scotland's date with destiny. It is right and just, Presiding Officer, in the 21st century, a country that is rich in natural resources, agricultural history, tradition, passion and talent is governed by the people who live in that country. The solutions to the problems that affect the day-to-day lives of Scotland's people are best decided and resolved by the people of Scotland. Scotland's people are best placed to make decisions over welfare, over defence and various other reserved matters. Scotland has been successful with devolved powers. There is nothing we can't do with independence. It is also right that in this bill it set in stone the ability for our young people to have a say in a referendum next year. No one, absolutely no one, has a bigger say in the future of Scotland than its young people. Because, Presiding Officer, young people are at their very nature don't stay young for long. At 16, young people can marry, have children and pay taxes. It is right they are given the right to vote on the future of a country in which they live in. Because before we know it, our young people will be leading this country, will be the new politicians, will be devising policy and enshrining the values that here in Scotland we hold most dear. The argument for votes at 16 and 17 has been going on for a long time. Organisations that play a significant role in the representation of Scotland's young people, such as NUS Scotland and indeed the Scottish Youth Parliament, have fought for many years for the right for people to vote at 16 and 17. I am proud that this Scottish Government has made this resounding commitment and indeed fulfilled a long-term SNP policy of extending the franchise to 16 and 17-year-olds for the most important decision that this country, Scotland, will take. We're not Brigadoon, we're Scotland. I am confident that when Scotland is an independent country, an SNP government or whatever government that governs this country will have the powers of independence, will extend the franchise to 16 and 17-year-olds in every election and referendum. With the right to vote comes a responsibility in our government to protect the young people who will be voting. And that's why I am delighted to welcome the measures that the Scottish Government has taken to ensure the stringent protections are in place for our young voters. We have a duty and a responsibility to ensure that both sides of the argument, both the yes and the no, express clearly their arguments, their facts and their plans for taking Scotland forward. I joined the SNP at 16 for independence for this country. I don't care whether it's a Labour Party governing it, a Tory Party governing it, a Liberal Party governing it, but I want an SNP government governing it because I want an independent country, a country that will look after its people, not go backwards as we are with the UK. We have a greater emphasis on the young people, particularly as this, for many young people, the first chance to vote and exercise their democratic right, a decision for a generation. The question right now in everyone's mind will be, what benefit does independence bring to me in my life? A fair and balanced question, Presiding Officer, and the answer is that with independence we can shape a nation that lives up to our ambitions of fairness and prosperity. In reality, what does that mean? Amongst other Scottish priorities, I am sure it means scrapping the bedroom tax. An SNP government and independent Scotland would scrap this unfair and unjust tax in at least well-off in society, a commitment our Deputy First Minister has made on a number of occasions. In closing, I note that convicted prisoners detained in a penal institution will not be eligible to vote in the referendum. Prisoners on remand not convicted will be able to vote. I totally agree with this proposal. As already has been said, if you live in a society and live by the rules of that society, then you are entitled to take full advantage of that society to vote. If anyone supports otherwise, would they honestly suggest, maybe they will later on, suggest that prisoners should decide their own sentences? I don't think so. On the 18th September 2014, I, along with many others, will be voting yes. Yes to a more equal and fairer, yes to an equal and more fairer and successful Scotland. I look forward to independence and I look forward to next year.
Thank you. I call Linda Fabiani to be followed by Tavish Scott.
Thank you very much, Presiding Officer. It was interesting to hear Richard Lyle finishing there on the issue of prisoners. Can I say that I've been sitting here wondering about the Lib Dem position because I came up with the government that they're in coalition with in Westminster made a statement recently saying offenders sentenced to a custodial sentence of less than 4 years would have the right to vote in UK Westminster parliamentary and European elections unless the judge considered this to be inappropriate, and explicitly stated that this does not include referendums. So I think it's quite interesting that we have Lib Dems here in Scotland trying to put the government under that pressure. Can I also say, and of course Patrick, but what I would say, Patrick and Margot, what I would say about is that you do not have people at Westminster in a government that is doing something completely different. Your points are valid. No, thank you, Patrick. Of course, that's not the only thing that the Lib Dems flip-flop. I think they actually made up that term on, because the other thing I was a wee bit concerned at a recent committee meeting was that the Lib Dem approach seemed to be pulling back from confidence in the Electoral Commission. And I would just like to put on record that we had both Willie Rennie, the leader of the Lib Dems in Scotland, backing the Electoral Commission, whatever their advice, he said, and also Michael Moore, Secretary of State for Scotland, putting on record that it was a highly respected independent body providing essential oversight and advice on the neutrality of the referendum process. Aside from that, I would like to talk a bit about votes for 16 and 17-year-olds and that extension of the franchise. And I hope that today at decision time we do endorse that extension to the franchise. It has been, as we've heard, SN policy for many years that the franchise should be lowered to 16 for all elections, and I know that's the case for many others in here too. But there have been great campaigns out with this Parliament that I think should also be recorded. That of the National Union of Students, for example, whose Robin Parker gave us such fine evidence at committee, and that of the Scottish Youth Parliament. Others have commended Emily and Andrew, who came along and gave us evidence. But I'd also like to commend the organisation of the Scottish Youth Parliament and all members of the Scottish Youth Parliament for that campaign, led very ably by their chairperson, East Kilbride's own Grant Costello, who publicly espoused the case with such conviction and passion. And I think it should also be noted, as reflected in their evidence, and this applies to the NUS as well, the fact that they were in discussion and very helpful to the government in formulating the proposals in the first place. Of course, if one is to vote at age 16, then it means that one must register at a much younger age. And that could be as young as 14, we realise in the committee. Therefore, committee members were very, very concerned that young voters had to be protected. It's absolutely crucial, and we took very careful evidence on that subject. I was pleased that appropriate witnesses such as the Children's Commissioner, the Association of Directors of Education in Scotland and the Scottish Child Protection Committee Chairs Forum were generally content with the proposals in the bill. And again, it was really useful to know that and be informed that they had indeed been speaking with government beforehand and taking their advice to the civil servants, and a lot of it was taken on board. And I think too that the Cabinet Secretary said at committee that she was still very open through this whole process to taking on board any other advice that those experts in the field could have. Yes, of course.
Margaret MacDonald.
I thank the member for giving me, but in all this care that's being taken of this group of electors, remember that's what we have decided they are, why should it be, if they are equally able to take the sort of informed decision that we will as more adult electors, why should they be protected in some way?
I think perhaps I didn't make it clear what I was saying here. It's at the point of registration, because in order to let people vote at 16, they have to be registered at a younger age than that. So, for example, if you're as young as 14 or 15, you wouldn't want that to be very obvious on the electoral register with an address and things like that. So that's the kind of thing that was taken on board. So there will be, for example, a separate register of young voters, which will be limited because of these issues. The discussion ongoing about dates of birth as opposed to age. And at a point further down the line, when they become voters, that's when the registers are merged, and that's when these people are 16 and not a child of 14 or 15 who wants that protection. So I am content that all of those who are experts in that field think that we have this right, that the bill is right, and that we can move forward in the knowledge that we are widening that franchise to allow 16 and 17-year-olds to vote. So very, very important, because, as we've heard from others, it is about the future of our nation. And I hope that we move forward to independence. And I also hope that in the independent nation of Scotland, 16 and 17-year-olds will be eligible to vote in all future elections. Thank you.
Thank you. And I call Tavish Scott to be followed by Stuart McMillan.
Thank you, Deputy Presiding Officer. Some of what the former editor of the Glasgow Herald used to say to me came back to me watching the news last night. Bill Clark, who was then the political editor, used to say when he phoned up, Tavish, I'd like you to comment on the war of words between Labour and the SNP. Don't worry, I'm not going to use it because I won't fit your comment in, but we should have a chat about it anyway. And when I watched the news last night and saw Gordon Brown attacking the Tories and determining the union was better for Scottish voters, and then literally in the next clip, Nicola Sturgeon attacked Labour and pitched for the left of centre vote, I thought, gosh, no wonder the public are wary of what's going on at the moment. Nicola Sturgeon went for the left of centre vote yesterday, but today the SNP's campaign, we understand, is for a pro-business cut corporation tax right-wing agenda. And we heard Fergus Ewing on oil tax earlier on. So they're left-wing on Monday and right-wing on Tuesday. So no party, Linda Fabiani, can shake a stick at the SNP when it comes to being all things to all people. But here's the problem. Here's the problem for the SNP. The voters aren't stupid. This bill is, yes, about participation, but to encourage interest and to ensure that the voter takes this issue seriously, it's not helped by the government being a tax spender one day and a tax cutter the next. Now, I do care about the battle of ideas and visions, but frankly, if I spent 3 weeks at home just now helping with a lambing, I would miss nothing on independence. The vast percentage of the population of this country has made up their mind, and no wonder, given what's been going on. So instead of the reforms Scotland needs, instead of testing the utterly debilitating orthodoxy of Scottish political thinking, of new solutions for old problems, this Parliament will shout at itself right through till September 2014. And because the government of the day will use their majority to railroad through their position on every issue and on every law, Parliament, in the eyes of an increasing majority of the population, is seemingly irrelevant. Now, today could provide a chink of light. It could be a genuine opportunity for that, and I thank Helen Eadie and Graham Pearson for their thoughtful contributions, more than we've had from over there. Thoughtful contributions on the kind of Scotland that we might create if we really... You know you're getting to them when they shout at you, don't you? You really know when they'll start badgering away on the left wing over there. On the left wing over there, the left wing, I suppose that will be one of the left-wingers speaking up over there. We could take a different position from the UK government, which would be progressive, right and part of a much talked-up tradition of Scotland's social fabric. And that was the argument that Graham Pearson and Helen Eadie, and indeed Patrick Harvey, has made, and Alison McInnes has made through interventions through this debate. Or we might not, of course. And now, if nationalist ministers don't support progressive change on prisoners' rights, that's of course their right. That's of course their right. But they should set out their principled case as to why Scotland should retain a complete ban, as Helen Eadie rightly said, on convicted prisoners voting. They should say why Scotland, being the same as Armenia, Bulgaria and Russia, is better than Norway, Sweden and Finland. And if Mr Stevenson wants to answer that question, I'm happy to give way.
Stuart Stevenson.
The member will be aware that the argument of prisoners' rights is found in Article 1, Protocol 3 of ECHR, which also reads free elections which ensure free expression and the choice of legislature. Given that Westminster has 52.4% of its legislators unelected, does he also support the abolition of the House of Lords?
Tavish Scott.
Yes, I do support the abolition of the House of Lords. Yes, I do. We hear many speeches from SNP ministers saying how Scotland's social and humanitarian fabric will be all the stronger if independence happened. Well, there's a pretty big gaping hole in that argument after today. You can't, on one hand, make all those speeches saying it's all going to be wonderful, and then not on this, yes, difficult, but undoubtedly progressive issue, simply ignore that particular argument. Happy to give way to Mr Finlay.
Neil Finlay.
Before he finishes his speech, I wonder if he would apologise to all of those who classify themselves as left-wing, because you've associated some of them with us.
Tavish Scott.
Far from me to get into what is left or right, but the one thing I do know Neil Finlay about is that he is left-wing. On this side, I don't know what they are these days. MSPs have today extolled the virtues of 16 and 17-year-olds being given a vote in the referendum, and rightly so. That's a genuinely correct decision. But that case would be stronger if, in deciding to include some of our fellow citizens, they explain why excluding others is indeed acceptable. The Justice Secretary said just recently, offenders should be sent to prison as punishment, but our prisons should also be about the rehabilitation and reintegration of offenders back into society as contributing citizens. He is absolutely right on that. Mr McCaskill is absolutely right about that, and I commend his approach. I wish he'd win the argument in his cabinet for a change in position in this areas. Allowing prisoners on short-term sentences to vote would, as the Howard League for Penal Reform observed, send a powerful message that they remain part of wider Scotland with a stake in our nation's future. To do the opposite is to send precisely the opposite message. So is this for this nationalist government an issue of morality, the law, or just politics? I sense that this is a political judgment. The principled argument, the progressive argument, the argument which of course will not find favour universally, is discounted. Discounted, I suspect, because the government have weighed up the political balance and want to be safe. Now that, of course, is their right. But with their majority, no progressive change in this area will take place on this bill. But what that does mean is that not only me, but many other Scots will observe that when faced with a genuinely tough call about building a better Scotland, this nation's politicians bottled it in favour of the politically safe status quo, and that is a shame.
Thank you very much. And now call Stuart McMillan to be followed by John Pentland.
Thank you very much, Presiding Officer. I too welcome the opportunity to speak in this debate, and at the outset I'd like to associate myself to the comments made earlier by Bruce Crawford, the convener of the committee, and also by the Deputy First Minister regarding the assistance received to the committee thus far. We have already heard a great deal regarding the issue of voting for 16 and 17-year-olds, and it's something I will return back to shortly. But I do actually want to raise the issue of equality, as indicated in paragraphs 139 and also 141. But before I actually touch upon that, just one comment just to Tavish Scott. Tavish was mentioning there regarding the lack of positive commentary thus far in the issue of the referendum campaign. I would suggest that Tavish actually speaks to his colleagues in the Better Together campaign to actually put forward a positive narrative as to why Scotland should remain part of the UK as compared to what we actually want to see Scotland becoming a normal, independent country. Regarding the paragraphs 139 and 141, the evidence that we received from the National Deaf Children's Society was certainly very much welcomed. And this actually followed on from an issue that I raised in committee regarding the colour of the paper used for the canvas forms for young people registering for the first time. Now, I raised this issue because I chair the Parliament's cross-party group on visual impairment, and I'm also a member of the cross-party group on dyslexia. I've got a number of constituents who are dyslexic and also a number of friends who are dyslexic. And they have raised the point to me on more than one occasion regarding when they actually access information, the colour of the paper is actually so important to them. So therefore, when I raised this issue in committee, I did it because I genuinely believe that registering to vote is important for every single election, and certainly for this referendum. It really is a chance to fully engage with younger members of society. However, I know that certainly representing constituents, there are challenges there. But if we really do want to make sure that younger people who are going to register for the first time, if we do want to make sure that they are actually going to register and they're going to feel as if they are taking part in the whole process, then we, certainly from the parliamentary point of view, have got to make sure that we are doing everything we possibly can to have that dialogue with them and to make it easier for them to ensure that they actually can register. I genuinely also believe that certainly for both sides of the debate, if both sides actually want to fully engage with the people of Scotland, then ensuring that the official documentation, as well as the information documentation, is actually available for all of Scotland's people. Certainly I am keen to find out more information regarding the testing process that the Cabinet Secretary spoke about earlier on. Also, it was touched upon in our report. I wholeheartedly welcome the assurances provided by the Deputy First Minister regarding language provision. That was in paragraph 140. But I certainly would like to find out a bit more information regarding how the testing process is going, because I think it certainly is something that's important going forward with this referendum. I said I would go back to the actual franchise itself. And like certainly other SNP members, I believe that lowering the voting age to 16 for the referendum is the right thing to do. Furthermore, I would also like to see it happen for every single election. But I do, however, believe that lowering the age to 16 should happen. It certainly should happen for every single election, but in this referendum, certainly is that first step in that process. Sorry, it's not the first step. It's another step, an important step in actually taking that forward. But I've had many debates with 16 and 17-year-olds, both here in the Parliament when schools come to visit, but also outside of the Parliament. And in general, I found that the general awareness of current affairs of many 16 and 17-year-olds is something to be proud of. And I would also gently suggest that many over 18s could actually learn a thing or two from 16 and 17-year-olds. And it's already been touched upon, certainly today, regarding the consultation that took place with Scotland's Youth Parliament and the over 40,000 responses. That, to me, indicates that 16 and 17-year-olds actually do want to take part in the political process. They do want to take part in actually determining their future. And certainly for this referendum, it's for Scotland's future. I remember my first vote, which unfortunately provided an outcome that I didn't want. But I remember it, and I can only imagine that when a 16-year-old or a 17-year-old goes to vote next year in the referendum for the first time, it will be a huge thing for them because it's their first vote, but also because they will be helping to decide their future and the future of this country.
Final minute.
And certainly, just finally on this particular point, Presiding Officer, I do want to associate myself with my committee colleagues and their praise of Emily Shaw, MSYP, and also Andrew Dean's MSYP. Their oral evidence was a lesson for everyone coming to this Parliament, and actually, when they actually come to provide evidence. I would certainly suggest that people that go onto the website and actually examine what they said and how they said it. One final point I will briefly touch upon is that of the introduction of the individual voter registration, which has been introduced by Westminster. It's going to be delayed, and I've got absolutely no qualms about that delay. It's the right thing to do. However, I do think that the flexibility offered to the electoral registration officers to start the process on around the 1st of October in all parts of Scotland is the right thing to do. I'm sure that certainly if the Scottish Government actually stipulated that the registration process had to happen on one particular day, then they would have been accused of actually centralising the power. So having that flexibility and allowing EROs that flexibility is the right thing to do. And with that, Presiding Officer, I look forward to the continuation of this bill and going through the process. And certainly the people of Scotland they've got a choice, one of hope or aspiration, or one of austerity with the Union. Thank you.
Thank you very much. I now call John Pentland to be followed by George Adam.
Thank you, Presiding Officer. What people can do at what age has always been something of a girdle. The inconsistencies of someone being allowed to join the army and fight for their country but not to vote have been commented on many times. The voting age used to be 21 or 30 for women when they first got the vote. And I'm sure some of us here in the Chamber may have been among the first 18-year-olds to vote in the 1970 general election. And now we are talking about reducing the age further to 16. At 16, you can get married, you can work full-time, drink in a restaurant, buy a lottery ticket, but buying your own drink comes later. And by 17, you can also drive a car, but as it stands, you still can't vote. And as I said, it's a bit of a girdle. But considering what you can do at 16, it seems churlish to continue to exclude 16 and 17-year-olds from voting. And while today we are considering voting in the referendum, it has been proposed by Labour that reducing the age to 16 should apply to all elections and not just the referendum. And let's face it, and I'm sure we all agree, if you're old enough and mature enough to vote on the status of your country for the foreseeable future in a referendum on leaving the United Kingdom, then surely you're also fit to vote in elections that only put people in power for 4 or 5 years. And of course I recognise that the damage that can be done in 4 or 5 years, but unless it includes irretrievably breaking up a successful partnership with neighbouring countries, the damage can be largely undone after the next election. And of course, lowering the voting age is not as straightforward as some might imagine. For starters, there is the issue of how to compare the list of eligible voters without compromising the personal data of those who are not yet old enough to vote. But with a can-do attitude, such difficulties are not insurmountable. And then there are other complications. We want people from Scotland who are serving abroad in the UK Armed Forces and their families who are with them, including 16 and 17-year-olds, to be able to vote. By working together and not separately, the ERO with the MOD can ensure any difficulties this presents can be overcome. As regards to prisoners, and as my colleagues have said, we are not in favour of changing their normal exclusion from voting, but we should be able to see what legal advice the Scottish Government has received. Or is this where the can't-do attitude kicks in? So what I would say to the Cabinet Secretary, if this legal advice is available, why not just publish it and remove all doubt? We must also look beyond the issues of who can vote and who will vote. And there is no doubt,
From the Law Society of Scotland of 9 May 2013, which states that the Section 3 appears on the basis of the case law to be compliant with the Convention. That, of course, does not mean to say that the section may not attract a challenge, but such a challenge, on the basis of the current law, is unlikely to be successful. That refers to this issue of prisoner voting, just in case the view of the Law Society of Scotland is of any assistance to the member.
As I said previously, all I'm asking, if the information is there, why not provide it and then remove all that doubt? We must also look beyond the issues of who can vote and who will vote. And there is no doubt that the legitimacy of the referendum result will be subject to scrutiny with regard to the proportion of the population who do vote. Now, bearing in mind that voter apathy by the electorate that has seen the turnout drop for Scottish Parliament elections drop from over 58% in 1999 to about 50% in subsequent elections. And Scottish voting in Westminster elections was also down from 72.6 in 1997 to 63.8 in 2010, having been lower still in 2001 and 2005, which for the UK as a whole were the lowest turnout since the introduction of the universal franchise. The Electoral Commission estimates that the registration levels are running at a little over 90%, and that while unregistered voters may be as low as 6% in some areas, areas of high deprivation can be over 30%, and particular social groups in those areas can have more than half of those eligible remaining unregistered. We want a clear-cut decision that can settle the question of Scotland's constitutional future and put paid to the distraction of every issue being subservient to it and overshadowed by it. And this will not be achieved if there is a close result and a low turnout. Therefore, we must pay particular attention in the first instance to encouraging a high level of voter registration and, having done that, to encouraging a high turnout at the referendum. I welcome SCVO's intervention in this issue and their suggestions for targeting hard-to-reach potential voters who are notably more numerous in areas of social deprivation among young people and in black ethnic minority groups, as has been highlighted by the Electoral Commission research. So in conclusion, Presiding Officer,
and briefly,
we must try to inspire them to vote, not to put them off the idea. For many, this will be their first opportunity to vote. It will be a once-in-a-lifetime vote for everybody, and let's make sure that the running of the referendum does justice to that.
Okay, thank you very much. Now call on George Adam to be followed by Michael McMahon. 6 minutes, please.
Thank you, Presiding Officer. I'd like to agree with John Penley. We have to inspire young people to vote, because I think we have to ensure that we have the debate in such a way that people want to actually put their cross down in whatever part of the democratic process they are. But I'd like to thank the committee for the work that they've done, because votes for 16, 17-year-olds have been something that's been a part of my political life since I was 16. Unlike Richard Lyle, it wasn't 1966, it was quite a while after that. I won't say when it was, because I would embarrass the Deputy First Minister, Presiding Officer, because there's a year of a difference in her age, so that just wouldn't be polite. She's obviously done a lot better over the years. She's not had the hard paper round that I had. But can I say I remember how it felt during that 2-year period, Presiding Officer, between 16 and 18. I can just about remember that far back. You're an adult, but you're not believed to be responsible enough to vote. You know, I was politically involved, but I was involved in the process, but I never had the opportunity to actually make a decision on the future of my own community or anything within the country. And I was politically active, but at the same time politically powerless. And some of the debates that we had then were probably very similar to the debates that we are having at the moment, because during that period, it wasn't Trident on the Clyde, it was Polaris on the Clyde. I'm showing my age now. They were talking about the replacement for Polaris. That debate's still going on just now as well. Instead of the bedroom tax, you had the poll tax. And it shows in my opinion, Westminster doesn't change. It doesn't make any difference. We're still having these debates now, and lots of young people who are involved want to actually discuss about these things and want to vote on these issues because they want to see what can happen in the future. And I think part of the reason we have difficulty with engaging with the public, with the political process, is by the time some people get to a certain age, they become very cynical about it because they haven't seen any progress. And for me, that's what independence offers. It offers the opportunity for all of us within this debating chamber to show what we can actually do and talk about Scotland and what we can do. Give us an opportunity to tackle child poverty, another issue that we discussed way back then as well, and ensure that we don't get dragged into illegal wars over the years as well. So all these issues young people have opinions on, and it's important that that they get this franchise for 16 and 17-year-olds. They get the opportunity to be involved in the ambitious new Scotland that we all want. Now, all this has been brought about by the Scottish Government negotiating with the Westminster Government. Incidentally, Presiding Officer, I look forward to the Scottish Government negotiating in the next couple of years, the Deputy First Minister continuing their good work on that side, because I think this is what we have to ensure, to look that we get Scotland that we are all looking for. But when you look at some of the groups that have been involved and have mentioned to the committee about what they actually want, as already been mentioned, that Robin Parker, the NUS, says it's extremely positive that Scottish Government and Westminster Governments have agreed that we extend the franchise for the referendum. There's also been the Youth Parliament as well has campaigned for votes for 16s for more than a decade. These are all people who are desperately wanting to get involved and want to ensure that everyone can be involved in the debate that we're having. I'm pleased that the Cabinet Secretary stated that the electoral roll will be dealt with in a manner that will ensure that 16 or 17-year-olds will be dealt with respect. I think some of the issues that my colleague Linda Fabiani brought up about when they're doing the roll, it's important that we ensure that the register of young voters will be strictly limited, as was said, because I think we have to make sure that there is still a form of protection with people who are obviously 15-year-old when they're going to be doing the registration themselves. But when you look at some of the people, some of the groups that have supported it, the EIS have strongly supported extending the franchise to all 16 and 17-year-olds for all future elections, and I agree with that myself, because I think it's exactly what I said earlier on. We have to make sure that we manage to enthuse young people when they first start getting involved in the political process, so that they remain involved and they continue to take an active part within public life in Scotland. My own Union Unite have a long-standing policy position that allows young people to vote for 16-year-olds. Yes, no problem.
Jackson Carlin.
I wonder if the member is confusing enthusiasm with extending the vote. The participation of people aged between 18 and 24 who have the vote already in elections is decidedly low. How does he propose to enthuse them? It's not just a case of extending the franchise, it's extending the franchise and encouraging people to use it.
It's the same for just about every other kind of age group throughout the actual demographic when you look at it. But you have to, the whole idea is it's what we're actually showing, what we're showing the public, how we're going to actually make a difference. People end up disengaging because they don't actually believe and become very cynical with the politicians. It's about vision, it's about passion, it's about the future of the country. That's what's going to make a difference for a lot of the people involved. One of the things that was mentioned as well was the idea of prisoners not voting, and I would have to agree with the Scottish Government's view that if individuals do actually commit a crime, then they have broken their pact with society, and that they should possibly look at the situation. I wouldn't agree that they would have an opportunity to vote, but one of the things that I would say to some of the Labour members, just gently remind them, is that the Labour Shadow Justice Secretary, Mr Khan MP, said on the issue of prisoner voting, Labour has consistently believed that those deprived of their freedom after being given a custodial sentence shouldn't be entitled to vote. While we recognise the importance of the European Convention on Human Rights and the European Court of Rights, we feel the original decision back in 2004 was wrong, and that's why the Labour Government didn't implement it. So when it looks at this, the Labour Party members can say that they don't actually want the franchise for prisoners, but that's not what's been said down at Westminster. So in closing, Presiding Officer, I would say that the whole idea for getting younger people involved, in particular with politics at an early stage, ensuring that we can enthuse them and be important parts in an engagement with the political process is an important thing, and I look forward to that in the future.
Very much. I now call on Michael McMahon to be followed by Jamie Hepburn. 6 minutes, please.
Thank you, Deputy Presiding Officer. Thanks for giving me the opportunity to make a short contribution to the debate on an issue that I don't think has come up yet this afternoon. Like many members of the public and commentators out there who are interested in the forthcoming referendum, I look forward to the time when the process of the plebiscite makes way for the debate on the substance of the issue. In the meantime, the technical aspects of the referendum vote have to be addressed. So I welcome this bill, although, like organisations such as SCVO, look forward to moving towards a wider discussion on how we encourage all those Scots who will have the opportunity to vote next year to get involved in that debate. But on the technicalities of the referendum, I have to say that I remain concerned over one aspect of the financial memorandum, which, as a member of the Finance Committee, came to our attention when we looked at that aspect of the proposed legislation. This bill, unfortunately, is now another in an increasing list of bills whose financial memorandum has not withstood the rigours of the committee's scrutiny. Recently, under the under-occupancy legislation brought before us, the Scottish Government had been less than robust in defending the financial assumptions that they presented to Parliament. That previous legislation was considered to be tens of millions of pounds out in its projections, and the best defence that the officials could come up with when they came before the committee was a hope that they were right rather than a detailed rebuttal of the concerns raised in relation to their financial assessment. Now, while the disparity in relation to this bill is much less in degree and can be counted in a few £1,000s, there remains a difference, and it is a technical problem with the financial memorandum. But the principle remains the same, that a lack of financial robustness emerged during scrutiny, and I think it is worth to highlight that difficulty. In the case of this bill, the financial memorandum, we were told, was calculated on the basis of advice received from printing companies that printing and postage costs accounted for roughly 25% and 75% respectively of the cost of printing and distributing forms. Now, I welcome the fact that government officials agreed to look again at this area of the financial memorandum and their assumptions in relation to that section on the cost of sending out reminders. Unsurprisingly, having done so, and using information provided by contractors who currently provide this service to registration officers in Scotland, the Scottish Government officials have now concluded that the cost of issuing and receiving reminders, purely in respect of the young voters' registration form, to 40,000 households, would be much more than the £6,000 outlined in paragraph 14 of the financial memorandum. Now, it may well be the case that significantly fewer than the 40,000 households projected in that section on the assumptions are likely, but in the event, they need to be taken into account, and to make one assumption in one aspect of the financial memorandum and to dismiss it later on is not an acceptable practice. So the estimate set out in the financial memorandum was therefore too low, and it has to be corrected. Now, I appreciate that officials have already written to software providers for revised quotes for the changes which may be necessary as a result of the possible changes to the electoral software. And as a result of that, the provision of this bill will have to be amended. And I welcome the commitment given by the officials to the Finance Committee that they are doing the same in relation to printing companies in respect of the forms that have to be sent out. However, they also advise that they will only be able to submit any subsequent revisions to the financial estimates provided in the financial memorandum just ahead of Stage 3. So I would be grateful, therefore, if the Cabinet Secretary could update us on the progress of this matter and commit to providing the information promised as soon as possible and not to leave it to the last minute. I doubt that the problem would, or even should, prevent the passage of this bill, but given the pattern of contentious financial assumptions being brought before the Parliament, it would be welcome if more accurate projections were before us for consideration so that reassurances could be sought sooner rather than later. Thank you.
Thank you very much. I will now call on Jamie Hepburn to be followed by Patrick Harvey.
Thank you very much, Presiding Officer. Can I welcome today's debate as an important milestone along the way to the referendum next year, and can also thank the Referendum Bill Committee for their very helpful Stage 1 report. I want to pick up on a few of the issues raised in today's debate, but I do want to focus in particular on the issue of the extension of the franchise to 16 and 17-year-olds. Let me be clear, a referendum on Scotland's future should let the future of Scotland have their say, and I think it would be fair to define Scotland's 16 and 17-year-olds as the future of our country. And the extension of the franchise to 16 and 17-year-olds is something I have personally supported for some time. I think has been remarked upon. 16 and 17-year-olds can enter the world of employment, they can get married, can have children, and they can join the armed forces. So I believe that we should grant 16 and 17-year-olds the right to vote. And I understand that there have been arguments about 16 and 17-year-olds not being endowed with the full swathe of rights that those who are older may have. I think John Penton referred to this as a bit of a guddle, but so the question is positive, so why should people be endowed with the right to vote? Well, I think it would be important to note that we don't enfranchise people on the basis of having a uniformity of rights, but because they might be endowed with certain responsibilities, and we allow for that possibility with 16 and 17-year-olds, and we should be giving them the vote. And I have to say the arguments that have been placed against them seem to me to be somewhat spurious. The old idea that people of 16 and 17 are not mature enough to get the vote. It sounds, although this was before my time, I should make the point, President Officer, but I think very much the same arguments were made when the age of enfranchisement was lowered to 18 from 21. And it would seem ludicrous not to enfranchise 18-year-olds now. And I think we should also, perhaps as an aside, make the point we don't actually enfranchise people on the basis of their maturity, which is probably a good thing for many of us, it has to be said. And in terms of this other argument that the turnout might be low amongst those who are 16 and 17, this was the argument that Mr Carlaw was reasonably making, given the evidence of 18 to 24-year-olds. I think it's clearly important to infuse voters of all ages. I think that's incumbent upon us all of us, those of us who are involved in the political process. But I think we should be clear, we don't again enfranchise people on the basis of their likelihood to vote. We do so on the basis of them being endowed with certain responsibilities, and therefore they should be endowed with certain rights, and I think that should include the right to vote. Now, I would suggest that probably a lot of this is a bit of a moot point now anyway, President Officer, because although there isn't quite uniform agreement at the committee, there does seem to be overwhelming support for giving the vote to 16 and 17-year-olds. And I welcome this broad support, because it wasn't always clear that this would be the case. So I think it is a welcome step forward, and we have seen widespread support from, I think, Civic Scotland to extend the vote to 16 and 17-year-olds. We saw that in terms of the responses to the Scottish Government's consultation, Your Scotland, Your Referendum. A majority who responded suggested that they broadly agreed that 16 and 17-year-olds should have the vote, and many organisations have set out their support for that proposition as well. I want to turn to a couple of other issues, if I may, because I know there was concern had previously been expressed about armed forces personnel not being able to participate in the referendum. That is clearly going to be the case that they can do so. The franchise is going to be based on that for the Scottish Parliament and local government, which does mean that the following groups of people will be entitled to register to vote: service Crown personnel serving in the UK or overseas in the armed forces, or with Her Majesty's Government who are registered to vote in Scotland. Now, I accept that Patricia Ferguson has housed, I think, a reasonable concern about the sons and daughters of some who make a service declaration who still live with such people not being able to vote. But I do know that the committee has taken that on board and is urging the Scottish Government to discuss this matter with the UK Government to explore all possible options to enable young people to vote if they are of voting age, and I look forward to seeing where that might go. I want to turn also briefly to another issue, if I may, President Officer, because this was an issue that featured not so much in today's debate, but it featured quite heavily in our earlier discussions about the referendum. Dr Elaine Murray secured a debate, a members' debate on the subject, and that was the issue of extending the franchise to people out with Scotland. I would first of all observe that only 3 people of Scottish origin living outside Scotland submitted evidence to the committee suggesting that they believe they should have the right to vote. I think it's ultimately sensible that those who live here are those who determine Scotland's future. And if I may, I think this has also been the basis for previous referenda. Henry McLeish made a speech on the 3rd of June 1997 when he was the Minister responsible for the devolution referendum, and he said the key criterion for deciding who should vote in terms of our proposals must be residency. I accept that people in parts of the United Kingdom other than Scotland and Wales will have a genuine interest. Eligibility to vote must depend on more than just interest. I think that's a sensible position at that time in 1987, and it's a sensible position now. Let me conclude, Presiding Officer, by saying I welcome this debate. I look forward to the bill proceeding to stage 2, and above all, I look forward to this bill, the referendum, the main referendum bill, being passed through Parliament. We can move forward to that referendum, and then Scotland can move forward to independence.
Thank you very much. We now move to Patrick Harvey, to be followed by Claire Adamson. Up to 6 minutes, please.
Thank you, Deputy Presiding Officer, and I would like to echo the convener's thanks to my fellow committee members, our clerks, advisers and those who have given evidence. Like other members, I'm very excited to be passing a bill which reduces the age of voting to 16. I think this is an extremely positive move, and like others, I've visited schools and school groups here, and I tend to find pretty much the same range of enthusiasm, awareness, interest in politics as I do at other public meetings or out on the doorstep with other age groups. It seems completely wrong to deny young people the right to exercise that vote if they are interested in doing so. Like other members, Helen Eadie, I think, was the first person to mention this. Others have as well. I want to see that voting age reduced for all elections. Now, what we're doing with this bill could be a huge step towards that or a step away from it. That will be determined by turnout. If we see a pitiful turnout of 16 and 17-year-olds, we may well harm the wider, longer-term argument, whether for Scotland or the UK, to advance the case for a reduced voting age in elections. It's down to all of us to try and achieve a really high turnout to ensure that the education, the engagement, the promotion of participation is of a really high standard. If we get a very high turnout of 16 and 17-year-olds, we will have hugely strengthened the case for wider changes to the electoral franchise in the future in Scotland or in the UK. And so I look forward to doing that. For most of my remarks, Presiding Officer, I want to address the issue of prisoners voting, convicted prisoners voting. And I acknowledge that the Deputy First Minister has said on several occasions, here and in committee, that it's for those who seek to advance a change to present arguments in favour of that. I intend to try and do so, but I reject entirely the implication that the Government is not advancing a change in the position here and doesn't need to demonstrate arguments for doing so. Generally speaking, it is the electoral franchise that is used as the basis, as the starting point for the franchise on referendums. And the Government is trying to advance a change away from that. Section 3 of the bill implies that even if UK legislation on the electoral franchise is brought into line with human rights, with ECHR. This referendum will not do so. This referendum will continue to apply a blanket ban, even if the electoral franchise is changed. So the government needs to advance a reason for doing that, just as much as those of us who want to argue for the principle of ending the blanket ban on prisoners voting need to advance our arguments. And our arguments are practical, as well as legal, as well as principled. On some of the practical arguments, the blanket ban throws up so many anomalies. You could have two people given exactly the same sentence on the same day, but because one of them was judged to be more of a threat to the public, they were serving parole, and that's knocked off the end of their sentence, and they are released earlier and could be able to vote. Could be able to vote precisely because they were considered a more serious threat to society than the person who was at liberty up until the point of their conviction. There are anomalies that arise that have to be resolved through the ending of a blanket ban. That doesn't mean that we can't have other approaches, leaving it to the individual courts in making a sentence to decide whether someone has committed a crime which justifies the deprival of the franchise, or having a time limit, such as I've suggested, of 6-month sentences, or the longer time limit that the Liberal Democrats have suggested. There are a range of alternatives to the blanket ban which avoid some of the practical consequences. There are legal arguments, as we've had, and Article 3 of Protocol 1 of the ECHR does seem to specify elections. It uses the phrase elections under a secret ballot under conditions which will ensure the free expression of the opinion of the people in the choice of the legislature. And this has been taken to mean elections and not referendums. But it leaves it entirely up to national governments, and in this case to a devolved government, as to what the case should be for referendums. And so any position which says we support ECHR, we want to incorporate ECHR into a written constitution for Scotland, and I agree with the Deputy First Minister about that. The Deputy First Minister therefore accepts that a blanket ban on prisoners voting in elections is wrong. It's not acceptable under ECHR. Why then is there a desire to have a different human rights attitude, a different approach to the human rights compliance in relation to referendums than in relation to elections? And the government should advance an argument in favour of that. There are also caveats which the evidence from Professor Tierney has made clear. For example, that the ruling on referendums related, for example, in relation to the ECC referendum, that it was seen to be purely of a consultative character. And that's part of the reason why the ECHR ruling did not apply to it. There are legal arguments which then indicate that the outcome of a challenge is unpredictable, not guaranteed. Finally, Presiding Officer, there are moral arguments, and although I disagree with the Church of Scotland about many issues, such as the nature of society, the nature of existence, they argue very clearly that the criminal justice system should have at its heart the aim of restoring broken relationships between the offender and the community. Punishment does not seek to deny human dignity to anyone, but to restore it. And that is the moral case that I think the government must also respond to.
Thanks. We now call on Claire Adamson to be followed by Margot MacDonald.
Thank you, Presiding Officer. If I could share with the Chamber today that my family is a bit stressed at the moment, but if I say that is due to the fact that my son is sitting his standard grades, people will understand that that of course means that he will be one of those teenagers who will be a benefit of the extension of the franchise, and he will be able to vote in 2014. So I did ask him, and more importantly, he gave his permission for me to share with you what the opportunity to vote meant to him. And he said, "I'm pleased, really pleased, that people trust us enough to let us take part." And, Presiding Officer, trust is what I think is key to this decision, about trusting our young people to take part in the decisions that will affect them. My son is very much in my thoughts at the moment for obvious reasons, but I was thinking of a visit that we had when he was a bit younger to the Houses of Parliament a few years ago, and we went to St Stephen's Hall and saw the damage done to Falkland statues by one of the suffragettes who chained herself to the statue when fighting for votes for women. It was very emotional for me, and more so because I was able to share the experience with my son and explain to him about what the suffragette movement was about. He recently took me aback when he asked if I would have been a suffragist or a suffragette, which gave me pause to think, but I think I'll keep my own counsel in that response. But we should not lose sight of the fact that extending young people the right to vote, how important that right to vote, how hardly fought for at an incredible cost to so many over the centuries, held dear by so many and unfortunately denied to so many others, and so recently exercised by the citizens of Pakistan, how important that right is. I'm very proud to serve as an elected member of this Parliament as we extend the voting franchise to our young people. I would like to turn to Mr Tavish Scott's contribution today, where he admitted to being a confused Liberal Democrat. Didn't seem much of a surprise to me. He says he doesn't know where we are. I'm afraid I won't lose sleep over that, because the Scottish people know where the SNP are, and that's why they delivered the Scottish people delivered the overwhelming majority that we have in this Parliament and the support for us. I do suspect that Mr Scott is perhaps losing sleep over his party's performance in the local elections last week, after shackling themselves to the most right-wing socially divisive party in recent history. But I have to say to Mr Scott that when Mr Cameron brings forward his UKIP-driven referendum on Europe, that the same rules will apply to his referendum as does to this. And it was indeed Mark Harper who said, "The right to vote will be restricted to UK Westminster Parliamentary European elections only, and not in other elections or referendums." Presiding Officer, I hosted an event in the Parliament last year for the Awards Network. This network brings together many voluntary youth organisations, uniformed organisations and some of our charities in celebrating the non-academic achievements of young people. Included Duke of Edinburgh Award participants, the John Muir Trust, Scouts and Guiding Associations, sports associations and charity fundraisers, including the hundreds of children from North Lanarkshire who participate in the St Andrews Hospice Climb with Ben Nevis every year. Our young people are conscientious contributors and responsible citizens. They are tackling some of the most serious issues that affect our society. Stand Up to Sectarianism, the Mackin Trust in Larkhall in my region, and those participating in the Mark Scott Leadership Awards are tackling and challenging the blight of sectarianism in our communities. I trust these young people to take a full part in the referendum. Our 14-year-olds who will have the vote have spent their entire school lives studying under Curriculum for Excellence, which is underpinned by the four capacities of successful learners, confident individuals, responsible citizens and effective contributors. I can think of no better reinforcement of responsible citizens than extending the franchise to vote to these young, responsible citizens. It is my ambition that all our young people will be informed, fully engaged in the referendum process. And I hope that they will vote. As has been expressed by some of the members already this afternoon, a good turnout in the referendum is to all our benefit. I have some sympathy, and I stress a very personal sympathy, with the Australian system of compulsory voting, but I recognise that no system is perfect and that we are all responsible for ensuring turnout at this election. If I could just finish on that note by talking about Abraham Lincoln's views on this. He said, "Elections belong to the people. It's their decision. If they decide to turn their back on the fire and burn their behinds, then they will just have to sit on their blisters." So, Presiding Officer, I do hope that on the 19th of September in 2014, however our people decide to vote, that we will wake up to few blisters, but a very confident and socially just Scotland looking forward to our future.
Many thanks. And now call on Margaret MacDonald, up to 2.5 minutes, please.
Thank you very much, Presiding Officer. I'm with Abraham Lincoln. He accepted that people were individuals and some folk would get too close to fire and others would have the sense not to. I felt this afternoon, Presiding Officer, that we've made a wee bit of a meal of the difficulty in holding a referendum. I'm old enough to remember the '79 referendum. I'm old enough to have taken part in it. And you know something? We didn't get into much of a fankle over information. The government of the day, that is Mr Callaghan, not of my persuasion, produced an information leaflet right at the very start, which tried in a very even-handed way to inform people of the different questions they'd have to answer. I regret that this government hasn't done the same thing, and if they're looking for somebody to write it, I'll do it. But I'm quite serious about that. I felt this afternoon we were a bit serious about how we're approaching this, because there's a lot of people actually quite joyous at the chance of getting a referendum on Scottish independence. And it's that, I think, that we should try and infuse in young people, because they are no different from old people. Some of them will, some of them won't. I've got 10 grandchildren, 10 of them, believe it or not, and I can't guarantee 10 votes come the referendum, because they will all do their own thing, and they'll do it at different levels of interest, just the way anybody else in any other age group does. So we shouldn't get too hung up in making exceptions in that. And talking of exceptions, I think we're going down a very dangerous road when we start to make exceptions of prisoners, the ones who might vote and the ones who might not vote. We will then start deciding what's a slightly worse crime than, say, drunk driving. Is beating up your wife worse than that? Because it can be too, that's the sort of judgments that a judge or a sheriff will make. We shouldn't make judgments like that. They're either prisoners or they're not, if you take the government's point of view, and you say, therefore, they shouldn't vote. Or else they are prisoners and therefore people about to rejoin society, if you take the point of view of some others on this side of the House, and you have a different set of criteria by which they're judged. So we haven't, by any manner of means, worked out this to my satisfaction.
You may wish to draw to a close, please.
And can I thank the presiding officer for the chance to be able to say this.
Pleasure. We now move to the closing speeches, and I call on Jackson Carlo. 7 minutes, please, Mr Carlo.
Thank you very much, Deputy Presiding Officer. We were visited in the Scottish Parliament not so very long ago by the Premier of Quebec, Pauline Marois. Now, she was very interesting. She had quite a lot to say on the subject of referendums and things that happen. She also, it turned out, shared with the Deputy First Minister and myself a very considerable and detailed interest in the doings of the fictional Prime Minister of Denmark. Her busy schedule, of course, hadn't allowed her the opportunity to engineer a personal meeting, but I'm sure she would have welcomed that. But the point she made was, and I think this is something we should be mindful of, that in the two referendums that had taken place in Quebec, the turnout that they had in their general elections was similar to our own, but the turnout they had in the referendum was in excess of 90%. And I hope that the one thing that we can all be agreed about is that what we need to ensure in terms of the registration of people in Scotland next year is the widest possible registration of everyone in Scotland to participate in that referendum result when it takes place. And I think that that may have a lasting impact, this referendum, on the participation thereafter of people in Scotland in elections to this Parliament and to Westminster, I trust, going forward. And so it's important, I think, first of all, that we make sure that takes place. Now, there have been two areas of controversy. I'm inclined to accept the point that Jamie Hepburn has made, that one of those areas of controversy is sadly or unlikely to be widely shared. It is a concern that remains of the Scottish Conservatives, and that is the question of whether or not 16- or 17-year-olds should vote. It's certainly the case. It may not be that you are better together, but you're all bundled together this afternoon in a view that 16- and 17-year-olds should have the franchise extended to them. And personally, I remain actually fairly open and sympathetic on this issue, but as yet not fully persuaded. And fundamentally, and it's a point Stuart McMillan made, but I don't think he intended it to support my argument, that it should not be for this referendum, but a decision that is taken in respect of all elections which take place, whether in Scotland or in the United Kingdom, and that this should not be, in some senses, a guinea pig for that proposition. And I'm mindful because when we talked about the extension of the vote to those in prison. Yeah.
Jimmy Hepburn.
In making the point that he does about wanting to potentially see the franchise extended to 16 and 17-year-olds on a wider basis than just this referendum, would he accept the limitations of this Parliament in doing so?
Yes, I mean, I think this is clearly a decision that should be taken in respect of all elections throughout the whole of the United Kingdom. So I'm not minded in this instance to support it in respect of this referendum uniquely so. We did hear when we were talking about whether or not countries should be extending the franchise to prisoners of those countries that do not. But, I mean, in terms of 16 and 17-year-olds, there were very few lists quoted then. And yet, amongst those countries, a limited number of countries that have 16 and 17-year-olds voting are Iran, Nicaragua, North Korea, Cuba and Sudan. So, for those who want to make an argument listing countries on one side, it's perfectly possible to list countries on the other. It's certainly not, and this is the point I want to make on behalf of the Conservative Party who will vote against the principles this afternoon, that we believe that young people are not mature enough to make this decision. I believe they are every bit mature enough. 5 minutes in the company of many 16-year-olds will persuade me that they're far more mature than many of the voices I hear expressed behind the Deputy First Minister most weekday afternoons. Mr Hepburn again.
I had thought you might give way on that point, Mr Carr, but I do thank you for doing so. Just in relation to the list of countries where 16-year-olds can vote, you omitted the Isle of Man, Jersey, Guernsey, Austria, Brazil and Germany in relation to elections to land or state elections, just to put that on the record.
Well, that was very kind of you, Mr Hepburn. I don't think it quite excused the rest of the company that was amongst all of them. Mr Mason intervened at one point this afternoon to say that, and I actually began to think it was an occasion I was with him, when in front of a school it was raised whether or not they felt they would have the sufficient information at their disposal. What he didn't say, in fact, was his old school. Which, as I understand it, when we were both present. So I thought it was quite something that they were querying the point. But I don't think it is an issue of whether or not young people are mature enough to consider these issues. For us, that is not the issue in hand. Nor do I fear the verdict of young people, and in fact one unintended consequence, which I might find beneficial, of the fact that it would appear that we will proceed on the basis of a franchise which will include younger people aged 16 and 17, is that I believe that their verdict will be every bit as decisive as the verdict of the rest of the electorate in rejecting the proposition that is put before them, and that the unforeseen consequence for members on that side of that will be that it will further render invalid their argument that there is a campaign to be had for a second referendum thereafter, because a generation well into the future will have decided that that is not the course that they wish to have. For us, it is a question of principle, and that principle is that this should not be a decision which is taken uniquely in respect of this referendum. It is a decision that should be taken in the round and after further consideration in respect of all elections, not just the referendum. The other point that was made principally this afternoon by Mr Harvey, that the franchise should be elected, and some others made it to include prisoners. I accept the verdict of the government in this. I thought Bruce Crawford set out the evidence that the committee had heard on this point, and I thought Mr Harvey actually touched at one point on what I thought the principal difference was, that the ECHR applies to the election of individuals to a legislator by law as part of a democratic process. The referendum is a creature of that legislature which decides to take and consult with the people, but ultimately its decision is not binding. That decision will then be taken finally by the legislator that commissioned the referendum that took place. So for that reason, I don't favour the extension of the vote to prisoners, nor, as I said earlier, to the area of young people aged 16 or 17. But it certainly is not because we have any lack of confidence or belief in the issue of young people being able to decide issues of great consequence for their country.
Many thanks. Now call on James Kelly. Up to 9 minutes, please.
Thank you, Deputy Presiding Officer. Before I begin, can I draw members' attention to the entry in my register of interests? My brother is Tony Kelly, solicitor and sole proprietor of Taylor and Kelly, a legal company. Can I begin by thanking the clerks for the work that they have done in support of the committee, also Spice the advisers, and also pay tribute to the committee convener, Bruce Crawford. I think on the issue, leaving aside the Conservatives, on the issue of extending the franchise to 16 and 17-year-olds, there was broad support in the committee, and as Bruce Crawford said, among the witnesses who we took evidence from, including Andrew Dean's MSYP, who was part of a consultation of 40,000 responses, there was a fair degree of support from young people to extend the franchise in this referendum to 16 and 17-year-olds. And as John Pentland argued, there is a strong case for extending that to all elections. I think we all hope that that participation in the political process will strengthen the process and also hopefully result, but shouldn't be the be-all and end-all, in more young people participating. I think in terms of the main issue of difference this afternoon, it's clearly been on that of votes for prisoners. I think it's been an interesting debate, and we've heard different views from different parts of the chamber, and I think a stage one debate is an opportunity for people to do that. There are two. Yeah, I'll take the intervention.
I'm very grateful to the member for taking an intervention. There's been much praise this afternoon, rightly so, for our 16 and 17-year-olds and for our young people being involved in the process. At the start of March of this year, the Scottish Youth Parliament voted by a majority in favour of extending the right to vote to prisoners. Were they wrong in that and right in everything else?
Well, I was just, perhaps if you'd allowed me the opportunity to expand on my views in that area, I'd have dealt with the point of your intervention. I think there are two issues in terms of votes for prisoners, whether the franchise should be extended and also the legal issues around that. In terms of the extension of the franchise, I'm not persuaded that that should be extended. I look at examples in my own constituency where constituents have been victims of domestic abuse, stalking, antisocial behaviour, and even under the restricted terms proposed by the Liberal Democrats, I'm not convinced that people who commit those crimes and have to serve custodial sentences should have the right to vote in the referendum. Yeah, sure.
Patrick Harvey. Well, to Mr Kelly for giving way. He does what's always tempting in these kind of debates and lists some very serious offences, as though the implication is that everyone who's a convicted prisoner is a very, very bad person whom we should judge harshly. Is it his view that someone who's in prison for days or weeks for a very trivial offence should be treated in exactly the same way as some of the very serious offenders that he's talking about in relation to the franchise?
Well, as Mr Harvey is aware, as the SNP government, supported by others, have ended custodial sentences of 3 months or less, no one goes to prison for days or weeks. So that's not a valid example. I take the view that if someone is serving a custodial sentence, it's important. The debate around rehabilitation is an important one. And we need to ensure that prisoners get proper education, get proper support so that they can go back into society. But as they are in prison, perhaps if they reflect on, if you just let me finish this point, if they reflect on the crimes that they have committed that have resulted in them being sent to prison, then perhaps that might change their attitude and they would enjoy voting once free in society. Margaret MacDonald.
I thank the member for giving way, because we're into heavy territory here. Is it true or is it not true that someone could be doing a custodial sentence just now and someone would not be still outside with the thing on his leg, the leg tag, where previously he might have been in jail? Now, they both offended against society. Why should we judge the one who is in jail now, according to our administrative arrangements, more harshly than we judge the person who might have been there had he been sentenced now?
James Kelly.
I think the argument that Margaret MacDonald advanced earlier about different sentences, different approaches, merely confirms the view that extending this franchise could cause practical difficulties. I think the principle that if you've committed a crime and you have been put to prison, you lose. The principle just now is that you lose the right to vote, and I think that should remain. Though I do recognise that there are legal issues, and I think they need to be addressed in terms of the wider debate. In terms of the specific, I seem to have spent a lot of my time discussing this. In terms, and I've only gotten on to the legal issues. In terms of the legal issues in relation to the Scottish Government, obviously we had evidence from the Law Society and Professor Tierney, which broadly came down in favour of the Scottish Government's position. But even the Law Society submission concluded that the legislation, or proposed legislation, appeared to be compliant. Professor Tierney's submission said that the outcome of a legal challenge could be unpredictable. Now, at committee, I listened very carefully to the Deputy First Minister, and I listened very carefully again today. And the Deputy First Minister's position is simply to assert that what has been proposed by the Government is compliant, and to draw attention to the Law Society and Professor Tierney's submissions. And I don't think that's good enough. The Law Society submission is only one page, one single page. We need to be confident that this legislation can survive a legal challenge in court, and therefore, Deputy First Minister, it's incumbent on you to publish the details, show us the assessments, and don't hide behind the legal position, don't hide behind the legal submissions of others. Let us see what the Government thinking on it is. In terms of, very briefly, I'm sorry, Mr Mason, I've run way over on the prisoners' votes issue. I want to just touch briefly on some of the other issues. I think Helen Eadie correctly pointed out the importance of electoral registration, and I think it is important that we get the autumn canvass started as early and as consistently as possible. In terms of protection of young persons' data, as Linda Fabiani outlined in her contribution, we did hear a lot on that from the committee, and we were right to be wary of 14 and 15-year-olds, data in relation to them not being published. So it was correct to seek the reservations that we got. I think in terms of moving forward, it's important, it's incumbent on all of us to play a part in terms of raising awareness. I think the big issue, we're moving on to something that is a massive issue for Scotland. It's a really big decision. I agree with what Margaret MacDonald said to a certain extent, that up until now, we've got bogged down in the process. This is a big debate. It's about a clash of ideas. And moving forward this process, it's important that all of us in either side of the debate come up with ideas and policies that will motivate voters on either side to come to the polls, ensure we get a massive turnout. And obviously, I hope that will be a rejection of separation.
Many thanks. Now call on Nicola Sturgeon to wind up the debate. You have until 4:59, Cabinet Secretary.
Thanks, Presiding Officer. I think this has, for the most part, been a good debate with some good contributions, certainly some food for thought for the Government in moving to the next stage of this legislation. So I thank everybody who has taken part in the debate, and repeat my thanks of earlier to the committee for the very detailed work that they have done at stage 1. I want to turn straight away to respond to some of the particular issues that have been raised. I don't think it will surprise anybody to hear that I'll shortly come on to prisoner voting and probably take up most of the time that I have available to me dealing with that particular issue. But there was a couple of technical or more technical points that were raised in the course of the debate that I will respond to at the outset, just in case I don't get a chance later on. Patricia Ferguson and, I think from memory, Annabel Goldie raised the issue of Section 11 and the delegated powers. The Government has made it clear, and I am very happy to make it clear again today, that we have no specific intention to use this power at all. We have taken the power in the bill in order to provide flexibility so that we can make necessary adjustments to the provisions made by the bill. And it is important that we have that flexibility, because any adjustments would need to be made swiftly, given that registration officers will need to begin work on implementation as soon as the bill is enacted. The other point I think it is worth bearing in mind here is that this bill is very closely connected to the main referendum bill, and we have explained the reasons why the two are being done separately. That bill will still be subject to amendment after this bill is passed, and therefore we need the flexibility in this power to bring those two bills into sync, if you like, should that turn out to be necessary in light of any changes or amendments made to the main bill. So that is the thinking behind the power, but as I say, we have no current plans to use that power, and clearly the processes that would have to be gone through would give Parliament due opportunity for scrutiny. The other point that was made of a more technical nature was Michael McMahon. I'm not sure if Michael McMahon is still in the chamber, but he raised an issue about revision to the financial memorandum. The response that my officials gave to the Finance Committee on this issue undertook to submit revisions to the estimates ahead of Stage 3, not just ahead of Stage 3 as the member suggested. Revised estimates will required to take account not just of the issue that Michael McMahon spoke about, but also required to take account of any changes that might be made to the bill at Stage 2, which is currently scheduled for the 6th of June. So we cannot give that update prior to that, but we will submit any necessary revisions as soon as possible after that to allow the committee to consider the information ahead of Stage 3. So I hope those assurances are helpful on those two technical issues. Let me turn now to the issue of prisoner voting. I have listened very carefully to the contributions that have been made. Perhaps not surprisingly for somebody who is a former lawyer, this interests me very greatly. I do not think it is a black or white debate. I do not think it is entirely about right or wrong. I have thought carefully about this, and I have given careful consideration to reaching the view that I have reached, just as I am sure those on the other side of the debate have given careful consideration to their views. I think there have been some very good contributions. Graham Pearson, certainly in that part of his contribution, if not in some of the rest of it. Helen Eadie, I thought, made interesting points. Alison McInnes in her intervention to me earlier on. Patrick Harvey, Margot MacDonald. I hope Tavish Scott takes this in the friendly nature it is intended. I thought the tone of his contribution perhaps undermined the coherence and therefore the effectiveness of it. Perhaps he's frustrated at being languishing on the margins of the opposition benches. Who knows? But I think Tavish Scott is absolutely entitled to argue that whether or not prisoners get the right to vote is the key test of a progressive society. He's entitled to argue that. What he's not entitled to do is to assert that those of us who take the opposite view haven't given any reasons for it or thought about it as carefully as he has. So I hope he'll listen to the rest of my contribution on the issue carefully. I want to deal with the rest of my contribution and remarks on prisoner voting in three key chunks: principle, law, and the issue of consistency that Patrick Harvey raised. I might then have a word or two to say about the Labour position, and I will come back to that later on. On principle, I believe, as everybody in this chamber does, in active engagement and participation in democracy. That is why I want 16 and 17-year-olds to vote. But I also have got a very strong belief in the balance between rights and responsibilities. And that's partly why I take the view that I do on prisoner voting, because I do believe that when an individual commits a crime and is sentenced to a prison sentence, a custodial sentence for that crime, when a judge considers that either the severity or the circumstances around it merits a custodial sentence, then they do lose several rights that the rest of us take for granted, including the right to vote. The right to vote for the period, if you just let me progress, I'll take an intervention if I've got time. The right to vote for the period that they are incarcerated. And I don't know if this is the point Patrick Harvey was going to make. I believe that for elections as well as for this referendum. I don't personally believe that prisoners should have the right to vote in elections, but I'll come back to the consistency point in a second. I'm going to make some progress, if you don't mind. On the legal position, ECHR refers to voting in elections to national legislators. It doesn't refer to voting in referendums, and that's why my view and the view of experts is that a legal challenge wouldn't succeed. On Patrick Harvey's points on consistency, I think the first and perhaps most obvious point I should make is this is consistent as things stand just now. Prisoners right now do not have the right to vote in elections. That might change in future, and it's not a change that is within the power of this Parliament. But we're legislating now, and I think it's important that we right now give certainty about the franchise for the referendum. And if the Government is not convinced at this stage on the basis of principle, then I don't think it would be a reasonable position to say that we changed the law in anticipation of an inconsistency that might arise at some time in the future. Yes, I'll take a quick intervention, if you don't mind.
I'm grateful to the Deputy First Minister, though disappointed that she seems to reject the view that ECHR should be complied with in relation to elections. And I presume the SNP is now going to dump the idea of incorporating human rights into a constitution for Scotland. But does she accept Jackson Carlaw's argument that it's about the non-binding nature of referendums that makes referendums different from elections?
Not necessarily, but I don't have time to go into that point. But I was coming on to the point. I of course accept ECHR, and I accept that we have to take account of what ECHR mandates. But what I'm saying is, if I don't personally believe that prisoners should vote in elections, then I don't believe we're under an obligation to go further than ECHR mandates, which is what extending the franchise in this referendum would be doing. So I've tried, as honestly and as frankly as I can, to lay out my reasoning. I will listen to. I have listened today to the points that are made. I will continue to listen. Members will have the opportunity to put amendments forward at stage 2, and Parliament will decide. If I can turn briefly, though, to the position of Labour. There are clearly differences of opinion on the Labour benches on this issue. I do not criticise that for a second. That is entirely legitimate. I would simply say to Labour, do not hide behind the fig leaf of government legal advice. This government doesn't publish its legal advice for the same reason that the last Labour administration in the Scottish Parliament didn't publish its legal advice, for the same reasons that past and current UK governments don't publish their legal advice, and we're not going to break that convention on this issue. When I was listening to some, not just now, when I was listening to some members of the Labour benches today, it was very reminiscent of the minimum pricing debate. When they were on that hook, they kept referring to the fact that the government hadn't published its legal advice. It was an excuse for being unable to decide or on the wrong side of the argument. Don't use it on this one. And interestingly, they've gone a bit quiet on the issue of minimum pricing since the recent court decision. Yes.
Ms Kelly, briefly, please.
Can the Deputy First Minister point us to one piece of evidence, in addition to the Law Society or Professor Tierney's submission, that you're able to use to back up your argument that that the position is legally compliant?
The position on this is the same as it is on any other bill. We take a judgment about whether we think the bill is ECHR compliant. We do that, and Parliament has to make its judgment. Now, I simply say to Labour, make up your minds on this. You're entitled to do that, but do not use the fig leaf of legal advice to get over some difficult issues that you might face. Presiding Officer, there's been a number of other issues raised on service personnel, on the children of service voters, on awareness raising, on interaction with individual electoral registration. These are all points that the Government will, of course, take into account as we move forward to the next stage of this bill. But in the meantime, I thank all members who have contributed.
Thank you. And it's now time to move on to the next item of business, which is consideration of Business Motion S4M 06561 in the name of Joe Fitzpatrick on behalf of the Parliamentary Bureau, setting out a revised business programme for tomorrow, Wednesday the 15th of May. I would ask any member who wishes to speak against the motion to press the request to speak button now. And I now call on Joe Fitzpatrick to move motion number S4M 06561. Mr Fitzpatrick.
Thank you, Presiding Officer. This amendment to business was agreed at Bureau this morning. It allows for the insertion of members' oath or affiliation to be taken by Christian Allard, who will join this Parliament as a member for North East Scotland.
Thank you very much. And as no member has asked to speak against the motion, therefore I will now put the question to the Chamber. And the question is that motion number S4M 06561, in the name of Joe Fitzpatrick, be agreed to. Are we all agreed? We are. The motion is therefore agreed to. And the next item of business is decision time. And there is one question to be put as a result of today's business. The question is that motion S4M 06545, in the name of Nicola Sturgeon, on the general principles of a Scottish Independence Referendum franchise bill, be agreed to. Are we all agreed? Yes. We are not agreed. Therefore, we will move to vote, and members should cast their votes now. Of the vote on motion number S4M 06545 in the name of Nicola Sturgeon is yes 97, no 12. There were no abstentions. The motion is therefore agreed to. And that concludes this debate.